Item 3.
You are Abu Bakr. Who are you? You have been called as a witness. Go and give a statement. CD interim. Within 10 days. When? 9th of October.
4.
Yes, Hagarika. On the face of it, we'll cross it then in a bail application. Page 7. So you want to say that sister-in-law came earlier, not after. That is the case. CD interim. But everything will depend upon this her statement. We cannot go beyond that. Yes.
Item number 5.
Where is the affair? Page 11. Don't seek time without the brief. In discourse, especially. Then we'll take up the matter. Page 11 is the affair, Mr. Das. Who is your senior? Bring your brief. Let him come.
Item number 66. Supplementary list.
Yes, Mr. Mahajan.
With all respect, my lord, there are false cases, my lord. I'm the owner of the plate clean, my lord. My manager reported me of around 1 crore rupees, my lord. Now, what has happened, my lord? I lost them as a hard. Of course, second in point of time, there I have taken everything. Now, in the first step, my lord, you can even look at page 11.
Yes.
All sections, my lord, regarding injury part, my lord, 325 days ago, my lord, page 11. If I read it in totality, it is the apparent on.
When were you arrested?
My lord, I was arrested on, my lord. We have respect, my lord. 7-9, my lord.
7?
7-9.
This 7-9.
But see only one thing, my lord, there cannot be any injury. Page 11, my lord, regarding Blick Clean, and that, my lord, I have beaten him up and taken his signature on blank papers, my lord. And they were taking signature in blank paper, that is non-bailable only, my lord. 386, my lord. With all respect, my lord. And thereafter, my lord, our affair, my lord, proceed kindly will look at page 31. Page 31, my lord. My wife has lost it, my lord, page 31.
Particular allegation by tying their hands and legs.
Say this, my lord. Can you see, my lord? With due respect, it is regarding money, my lord. first of all. And the agreement of money,
This is which police station?
same police station. One case subsequent, my lord, wherein I am checking there is 241, this is 242, and the agreement I have annexed, my lord, registered agreement, that is that, my lord, inform respect, my lord, page 23. Page 23, my lord, can you see? It begins at page 25, my lord.
Okay, what about page 17?
Page 70, I'll come to that.
Because it said that he is was to be admitted in SMCH Silchar.
My lord, that position definitely prove that I am the victim owner, my lord. And injury is at 325, my lord, they have it at 307.
But he's a grievous injury.
Well,
So if this is a case, otherwise it's a 7-9. We'll just see the case
Can
there.
it be on Monday, because unnecessarily I will take, my lord. My.
I have no problem Monday. If they say today at 2 scan copies, I have no problem. I have no problem. You make an effort, we'll on Monday, we'll see, along with the injury report. Monday. it will be.
I agree on that. I agree.
Item 67.
But here is a good thief was beaten up by a crowd, my lord. Definitely case diary, my lord, from normal zone.
All the- Yes, no.
It is possible, normal zone.
Yes, that is up to Das, because that is his domain. I cannot dictate.
Yes,
2-0.
I agree on that. I agree.
Standing item 5.
This is not a case for interview. Okay, anyway, wait for. In absence, grant is not issue, but in absence, denial is difficult.
25 seconds.
No, let him come. We're waiting for some time.
For motion item number 6.
Yes. Oh, that case.
Rejected on the one of today. For rejecting the petition, whether it was just for.
When is the next date?
Today it's for, I don't know. We have several judgment where it says that no one can be debarred from correcting the mistakes or error because human beings are prone to error. So if it appears that it was, my this was that the contradiction was not true.
You can have that. Okay, we'll pass this or otherwise today's date is otherwise gone. You will take adjournment.
No,
We'll get this order day after tomorrow. Dispose of.
Item number 7.
পরীক্ষা আসছে তাই না? Sorry, বলুন, হ্যাঁ? Yes, motion. Pace. No, what do you want? FIR pace. Why should you cause this? Why should you cause this? Come prepared. Under prayer of, no. These cases, we don't issue notice. You will satisfy us then only, is a notice, right? Leave this matter. Huh? Maybe you are on bail. That is not our concern. You want quashing of this FIR. Is it a ground that because a person has been granted bail, so therefore FIR should be quashed? Then Mr. Mahajan will file a bail application and next day a quashing application. Next week. Come prepared. This is not the way to do a case by young counsel. Yes. What are the parameters of quashing an FIR? That these are not there, no prima facie case is made out, abuse of the process of the court. So take adjournment if you are not prepared. Yes.
Item 8.
Yes. Mm. So I do this. Why do people straight away go to the apex court? Be here for time being. Let us understand the facts, then go to the apex court. I'll give you 10 apex court judgment that this is a matter whether consent was taken of misrepresentation of fact cannot be determined by this court. So therefore, that is a matter of trials if it is dismissed. Reported in. Do you want a judgment? Already charge sheet filed. Issue notice within a presence so registry to call for the scanned copies of the case diary as well as the scanned copies of the record from so. Considering the nature of allegation as reflected in the FIR, it is provided that till the next issue notice, till the next returnable date, further proceeding of so shall remain state. 6 weeks. Give a date, not 6 weeks. Give a notice to the informer. November 10.
Item 68 of supplementary list.
Yes. Salan was that Sabir Enterprise. Who are you? You are the middleman who got it printed in Azad printers. Is it that case? That case we have taken this case, I think, because I have not done. Okay. You are the middleman who collected. We granted bail to, I think, owner of this.
No, that one I know was we had prepared just by the 3 lines, 15 person, that 66 level.
This FIR I have already read.
Needed by supplemental file to the forest official in order to verify that establishes the fact that 63 consignment stores are received by supplemental file. Further, in the inquiry, it has been found that the suspected 56 4 dollars were acquired by supplemental file through middlemen, so and so my name was identified. So I put it. Then all these suspected 4 dollars were prepared by one available after. Further, the forest officials have already seized the 63 number suspected of Inusal and some then suspected for the
Whom we have granted bail, Mr. Das? I think we have granted bail to the owner of this enterprise because their statement was that they suspected this and then they went to the police, forest officer and showed it, then the investigation started. So according to them, they are the person who owned it. Now there are some middlemen, it was through whom it was printed in Azad Press.
This person all of the statements were recorded by the police, forest officer.
Acquired by your name is
I will-
middleman Inusal, so it would be. Hassan is very intelligent. And all this was prepared by one Ali Ful. Okay, considering the nature of allegation against the present petitioner and the fact that a specific allegation is made against one Aliful Ahmed to be the person who forced the who allegedly forced the forest salons. It is provided that the petitioner interim will appear and record this. Now all these will come. Nazrul. Now all this will come. Inus, Nazrul, Islam, Hassanus, Rohim, all will come now. Because forgery is done by only Inus. You are the middleman. Yes. If possible, bring the CD because we'll see how they are involved. Because everybody will come now with this order, similar prayer. Yes, yes.
Bail hearing BA, I think 18.
No, this is the scan copies. This is scan copies you call for. Non-appears for the petitioner on call. The scan copies call for scan copies of PRC case number 1503/2023 has already been received. Accordingly, learned additional public prosecutor is permitted to go through the same so as to assist this court. Please this method. Next week, give a date. 20.
Item 19.
Item 18 done. It's like river Brahmaputra. Yes. Neuropsychotic patient. Anything? Okay, after some time. He's a neuropsychotic patient. Two part. He did some, what we'll say, to his wife. Tomorrow? Tomorrow. Because two aspects in this matter. The document, medical documents are there, neuropsychotic patient. And the action or the offense he has committed, a man with a normal brain cannot do this. It's really cannot say to his wife. So he's in jail. Better he should have treatment. Earlier also he was advised to be hospitalized. If I recall, because today I have not seen not a single file. So far I recall, they refused to admit him. So if he needs a treatment, let there be a proper treatment so that this kind of things may again will repeat.
So they will come on Monday, but discussion of they can obtain in private.
Okay, Monday.
Much of budget, much of.
And medical, so Mr. Borua Learned Council, Learned Additional Public Prosecutor submits that he may be granted time till 18th to have the instruction as directed to obtain the instruction in terms of order dated 31/8/2023.
Item number 20.
What happened? Nobody is there. These are bail applications. Series there. What is the name of this petitioner? Rohit Shakya. What is the allegation? FIR? Hmm. Okay. So why he is made an accused? Any material against him? Considering the material so far collected. But I do not know whether he may be granted bail by the lower court. This is what is happening, what we have seen. Let him appear, wait for some time.
Item 21.
Yes, Mr. Sharma. Not on merit. What is the allegation? Oh, fake currency, CD will be required. How many days? 50? Be there for 10, 15 more days. Fake currency. It's a very difficult. Okay. CD is not received when? 22nd.
Item 22.
Yes, where is the FIR? How many days? CD? Huh?
Smallest fish in the pond, surprisingly, the big fish have become informant and witnesses, and I am the only person.
I have serious doubt. Because you are having the direct link with these members.
I'm not saying I'm totally, the big fish have not suddenly become the informant. Because in my capacity, it is not even possible for
You
me
make statement before the police that these are the big fishes. On their instruction, I have done it. We'll see the case there and ask the police to expand and to get the big fishes.
to.
25.
Item 23,
Same affair. Who are you? How are you related to this informant at page 8? Informant is your mother-in-law. Deceased is your husband. Okay.
About 1.5 kilometers away from my house.
Okay, at least today I have learned a new word. Burmese grave, that I was not aware. Leteki. What is the CD says? She suspects that her daughter-in-law has killed her son. And
After 8 days, one is mother, and the person immediate, other is immediate.
who is 58 days?
Other of the present,
The brother of the present petitioner is inside.
no, wife is inside and her mother is outside. Present living is 5 months pregnant.
Let it go. What you say?
So they have mother said that.
What is the postmortem report?
Because of this mother taking hotel, there is the biggest kind of mother. Company is to sorry.
Strangulation. You might be frustrated. How many days?
Other to 45.
Huh? Now, what is his role, brother's role? He helped.
They both
Let her go, considering only the period of detention and stage of investigation, and also considering the fact that the petitioner is carrying a pregnancy of 5 months. The present application stands allowed. Other is Renumia. Renumia is rejected. Huh? Item, next item. 45 rejected. This is not a fit case for a grant of anticipatory bail. From to BA, next to AB. CD returned.
24,
Now all these things are so easy, no? Instead of lodging an FIR, getting separated. She might have is also be having a frustration to the head. Yes, that we know. That's why today it is in the bail hearing. Now tell us the affair. Yes, CD is there. When? 25.
I think 25.
Mr. Burua, BA CD should be there. Either we reject or we allow. That is a different issue. BA people are inside. Yes. There is a FIR 9. Who are you? Huh? No, where you? Why are you? Why is arrested? Who are you? Okay, we have granted bail to someone in this case. Huh? Whom? We have given bail to. What is the forwarding report says? Why you have been arrested? Reason for arrest, sufficient evidence found second. What sufficient evidence? Something should be disclosed for court. How many days? Huh? Short date, short date. Have it, have it. Otherwise, we will give the bail if no CD comes on the next day. When? 22nd.
I think 69. or
On
something.
22nd, don't fix too much, Mr.
10 supplementary list.
Rohim Batsa and another. What happened to Batsa? Batsa is inside. Yes. Mm. Mm. Oh, that matter.
So I don't know what you can say. It's the- They have just both ended the first person.
Mm.
So for 10 in the-
How many days you are behind?
60 minus 76 days there. So what's what that just say now after 10 days you see that.
Mm.
And then, oh, Yoshimaro, this 2% was shared. Earlier also this traditional informant side by the case against that. There were two. In that case, where by the.
What is the stage of investigation? Tell us. And whether you require their custodial? Huh. FSL report of what? That you have sent to the FSL. They cannot influence the scientists of FSL.
There is no such I
Hmm.
what I found.
Considering the period of detention.
There are the
Also considered the hearing and the stage of investigation. Huh? SDGM business, 50,000 each.
Appeal number 5, timing matter.
This is not a case for interim, case diary. Case diary when, Urva?
From hospital.
Accused number 1? But still, this is we do not know, and we have seen some cases from this area, Rajasthan and Delhi, selling girls in Rajasthan and Delhi. This is not the only case. 27. 27, 9.
Timing appeal 20.
None appears for a petitioner on call. Accordingly, the present application sent this for default.
Bail hearing item 26.
None appears for petitioner on call. None did represent the petitioner when the matter was called on 21/8/2023. Accordingly, the present application stands dismissed for non-prosecution.
27.
Case diary not received. When?
Twenty-seven.
27.
28.
This for the meantime is there.
CD is there.
Kedari must have been
When?
10th of October.
10th of October, interim to continue.
29.
59 also I know.
When? 10th,
10th.
interim to continue. Okay, same order. So therefore, we are giving interim order. Whether it's HRA or you, no problem. Order is passed. The name will be recorded from the first page of the
30.
yes. 10 October or 12. 10, interim to continue.
31 and 32.
Yes, Mr. Khan. You are also an interim. CD receive. Okay. When? 25. Interim to continue in both the cases.
33.
This case for the time was there. That is by 70 years old. And the son has confessed the case that he was taking custody of the
CD is there. Okay. I just submitted that up-to-date case diary is not received. Accordingly, matter stands adjourned and be listed. 11/10 for production of up-to-date case diary, interim order compilation.
34.
When? 11:10, interim to continue. No CD, interim to continue. 11:10.
35,
Yes. When? When? 6:11, interim to continue.
36,
Yes. Same order. Same order, interim to continue. 6:11.
37,
No interim, so Monday.
59, 38,
Yes, Mr. Doctor. CD is there? No, CD is there or not? If you are on interim, CD is not there, we will not waste time. Yeah, okay. Now let us see the affair. What is the affair? Who are you? Topon Kumar Bhumik and others. How many petitioners? Okay. You are on interim. It is submitted that though case diary is received. However, the statement of the petitioners are not available on the same, though it is reflected from the record that petitioner has appeared before the IO. Accordingly, Mr. Borua, learned additional public prosecutor, prays that he may be granted some time to get an up-to-date CD. The prayer is allowed. The CD be returned back and be produced on 10/11 with 10/11. Okay. Is this interim order pass earlier shall continue. In the meantime, if the IO feels it necessary, the petitioner may be called to appear and get their statement recorded.
39,
Yes. Receive. Who is the affair? Yes, 9. No, let us first understand what is the allegation, what is the role attributed to you. Then we will go that whether recovery from you was important or not. Isn't it? So let us see that first. Page 9A. Particular. Who are you? You have been Rupjit Das. According to the FIR, Rupjit Das is the main issue. Okay.
I was thinking this stuff when you were elected. Yes, it's very good.
Okay, what is implication?
For example, is also input into this.
And he apprehends. He apprehends. Fake currency note. Let them investigate, get your statement. I think first, what cooperate? You will cooperate inside, they will give you treatment, rejected. Huh? He cooperate. Who has stopped you to cooperate? You have him. Should he pass that, you will cooperate and surrender before the. If you want that, we can provide that. That he will surrender before the IU and cooperate. And no third degree will be given. You want that? Rejected.
Section 40.
What is series receipt? Yes. What is the injury? Photograph is there. What are the name of these accused? Abdul, Inas, Ismail, and Zakir. Now Abdul Ghani. This is one petitioner. Abul Kalam. Okay, what is the allegation? Him. So, who was the injured? Abdul Rahim. Huh? Huh? Now question is, it's a fight between the two masjid groups. Money. He's Abdul Kalam. Stitches mean these are not called stitches. Where is the statement of the injured? Be now therefore some days, because the conviction is sure, sir. If the accused, the victim, what is the victim statement? What is your name? Abdul Azad. Abdul Kalam. But his name is not named by the independent witnesses. Where is the case diary produced? It is seen that the eyewitnesses has not named the petitioner in commission of the offense as alleged. However, specifically named one Innes Ali, Ismail Hussain, Yusuf Ali, Khairul Hassan, Zakir Hussain, and Shafiqul Ali has inflicted the injury to the victim Anwar Hussain. Considering the above, the present. Yeah, okay. Full stop. It is also seen that the petitioner has cooperated with the investigating authority. Accordingly, the story is of the view that no custodial interrogation is necessary. Accordingly, the bail application stands allowed. Yes, Mr. A.K. Azad is present representing the defendant. There is no allegation against him.
41,
That's why I made them intentionally mention the name because others will come and say similar. Manish is really. Yes, yes. Received up to date, for up to date. The order says it's up to date. Why?
We send message on one and once.
Okay, I had given early date.
Twenty-seven.
27th, for production of up-to-date case diary in terms of order dated 31/8/2023.
42,
Received. What is the FIR?
There are two petitioners. One the allegation is that we have ordered the other accused to murder. Is it believable that a person will ask someone?
Oh, nowadays these are believable because this is a profession nowadays. Instead of doing yourself, spend some money, you will get people. So this is believable. But whether you have done it or not, we'll see from the case diary. This is not an unbelievable step. This is a believable step.
From the inquest report,
Hmm.
some minor injuries are there. Sudden injuries.
When can we have the case diary?
This will be
Who is the FIR?
9. We have not participated. This was the initial that we have participated. Only that we have ordered.
Hmm. When can you have the because postmortem report is there.
This one is.
That is very vital. Whether it is a huh?
This report is there.
But whether it's a because allegation of hanging is there.
Only given to there. Particularly is not there.
No, is it required? Suppose there is a specific allegation by the accused that you have paid 1 lakh to kill him, then
How do you know? How do you know serious?
what is, we'll see the postmortem first. Required, otherwise difficult, serious allegation. And it's not that, not only instigation, they said you were present in the place of offense. And that is there. Instigation is not like that, you were present,
On 29.
29.
43,
Yes, huh? It is not there. When? Yeah. Huh? When? When? October. Sorted ask Mr. Das. That is up to Mr. Das. I cannot direct. I can direct tomorrow. Then if it is not there, then he is very liberal.
I think 44,
He cannot after some time. That's it. That's why. That's why there is no interim. That is, I recall this. I think I should know. I call for the case there without any interim. They tried to have interim because of the alleged that my house is. So do you need the presence of your senior or we reject it right now?
I think 46,
Yes. Yes, Goswami. Sitting of this. Form. When? No interim therefore. 29th.
I think
Interim.
47, along with item 70 of supplementary list.
Mijanur. Mijanur and Ajibur. Which matter should we take first? Item 47. Okay. Where is the FIR? We want to see non-translated because the translation has already frustrated us. Huh? Now this is another difficulty. This language is tougher than the foreign language. Okay, let us see the translation now. Oh, Ratul and Bablu. Raju and Bablu. Then it's not only the gold snatch away his money also. He, with the hope that he will get so much of money, came from Bihar. Now, what is their role? They are not some other, they are involved. How many days? How many days?
I think, 33 days.
Only.
Only allegation of terrorist that they are saying that. But
Ah.
find a case number, 15 of these is not only take the money, they were they do matter.
Or snatch the money.
Snatch the money. No, they were.
Because the person said, no, this is not the goal.
This is not. this is
That's
take
why
goal.
they snatch the money. Do you need them, this BA for any interrogation? No, not concept, tell us. What is the stage of investigation? Mijano we are not granting, that is for sure. Mijano we are not granting, that is for sure. Okay, you want both to be rejected or one to be granted? Tell us. Okay, BA granted, AB rejected. Go there and come back.
$48.
Yes, Sakya. Where is that? Yes. You are Mohendra Sakya and Bhaskar Jyoti Gogoi. Matter are simple, but he used cable and seriously beaten him up. What was the injury report? Grievous, it will be grievous. Was it a issue to beat a people like this? Yes. Paragraph? Both the parties are involved in quarrel. And what is the issue? Because both the people reach the bridge at the same point of time. So who will back the vehicle? It was a small bridge. And for that you will beat up people like this. Maybe, so you'll kill him and beat him like this. Rejected. Considering the injury report, this court is of the view that this is not a fit case for privilege of pre-arrest. Go there and come back, we'll give it. Yes, there is a fight, but will it permit you to beat up people like this? We'll see. What magistrate can do or cannot do, the case diary. Do you want that I should record all this? What was the injury? Give the CD. That you challenge the magistrate's order. We'll record everything. What was the injury? What is the injury report? Exactly. The affair was that with a car cable.
I'm not denying them.
So if you are not denying that, see the grievous injury. The view is that blunt object car cable.
That's true. I am not denying.
If you are not denying, this is anticipatory bail is a privilege.
But we said also,
Yes, it's fine, but are you injured to that extent?
Since he was in an email, there's some because of, not because of the fine.
So we'll have to say that medical report is,
Fine.
and the reason of cause of injury is a weapon, blunt weapon, a cable.
My prayer is that the first thing is there's no power there.
You silence the magistrate order, will look into that, not in a bail application. Rejected. Next case.
Number 49.
Yes. Are you having the brief? What is in your hand? Bring the brief from your senior. This is bail only, nothing is required to be argued. Yes. Afsar Ali and another. What happened? Afsar and Abdul Salam. Oh, that biscuit company.
Yes, and after that is all the well belongings.
One we have already rejected. Okay, let her senior come. Now these people are also seeking anticipatory bail. Good.
For orders, item number 50.
I have filed for cancellation of the bail. Who is for the informant? Why you want the bail to be cancelled? Case, case 27. The present application is filed for cancellation of a bail order passed in AB, is it? /3045/2022. Cancellation of bail order dated and 23/11/2022 passed in AB 3045/2022. The said order has been passed by a coordinate bench within bracket Justice Manish Chaudhary is accordingly registry to list this matter before appropriation.
For quashment, item 51.
Yes. Why should we, what is the wrong in this order? You will lodge an affair saying that these two person has raped me. Okay? And during 164 statement, you will say that it is a false case. They have not raped me. Then 161, you will say that not raped me, that these persons are suffered. So 211 is made out. So proceed. What is wrong? Maybe. No, we understand, but ultimately fact remains that you have alleged that these two person has raped you. 376. And actual fact is you yourself admit that no, they have not raped me. This is a false case. So magistrate has taken cognizance under 211 and asked to register. What is the wrong in this? And people like you should be proceeded. Otherwise, this will continue. If that's true, we are dismissing your petition. That we do not know. Where is that settlement? Come causing on that compromise. Then we'll see Lakshmi Narayan. That kindness we can show, but this is not the case for any stay. No, we are second. No, then we can. No, you argue. Okay, Monday. Tuesday. This is not a case. If people like you should be prosecuted. Otherwise, see, on your statement alone, the law is like this. On your statement alone, these 2% can be convicted for more than 10 years. Only on your statement. If you file a delayed FIR, law says, okay, Indian women rape, they may not come. Then no medical evidence will be there. Only on your statement, these 2% could have been convicted. You should face Tuesday.
99. Item 52.
Yes, Bhakti, what is this? Let the investigation be there, and then you get, if no case is made out, they will give an final report. Why should you quash an FIR? Yes,
That is the FIR.
yes,
And it is money.
yes.
The reference is the subject about. I have you only to show you that the home, the second information on person, expect hearing one person. That is the so that the Narayan is the later try to escape away with more issues. The later one gels down and intercepted the pressure of the game that doesn't seem Narayan on the result of the public.
So your case, what is your ground? Your ground is that the Assam excise cannot do anything against you. Don't be so excited. Gaurav, why are you? Always, you are always excited. Yes, take this. Yes. Where is the liquor now? Where is the liquor now? Oh, it will mature. We'll hear you after puja. Let it mature. According to you, they are having no authority. So let us hear why, from where you have.
In fact, this matter was validated. It is the second petition on the same ground, very technically drafted. But you will kindly see paragraph 9 of this petition.
Already decided.
Already decided and might not be operative portion of the order at page 26. Then we compare both, my lord, is the issue that has been decided, my lord, that we have the jurisdiction. With paragraph 9 of the petition, I am page 26 of the petition, at the last page, paragraph 18.
Para?
18, my lord. In fact,
Out of the same incident, same vehicle.
Same incident. Nothing has changed. Only there is a justification provided in paragraph 9 why this second petition is prepared. There is a camouflage, everything is same. Let's start with paragraph 16, madam, the order sheet. Says we have jurisdiction.
Have you challenged this order?
No, my lord.
So it says that they are having authority.
Yes.
Paragraph 9 is clear.
I don't think so.
So if it is your ground that it is a case that they are not having jurisdiction, that has been answered by a coordinate bench at forget about that. We assume that this is not your case. It is a different case.
Yeah.
Then also at paragraph 9 says, thus it has been, no.
No, this point has not been decided. So for this purpose, we will come to care of that. This point has not been decided. So that was for the release of the materials, minor, which is so much into our right. So that both are different. Apart from it, my lord, if you want to consider that this point has already been decided by the report. Even though I will submit that it is currently. Here are 10 minutes, last 4 lines. The idea
Kindly come to paragraph 15, page 25. Yes, read.
no, where the is made up. And there is no. I don't that is the and that's when I will.
No, just read it.
So under is one of the ingredients of this expression under English. And it is under English.
So it is under investigation. Any facet that has been discovered during investigation can be taken into account by investigating officer, and that cannot be registered only because such aspect was not reflected in the affair as contended by the petitioner side. Matter ends there.
No, mind of that is what you see. I must talk about your road to see whether the any opinion that is committed under section 23 of that. Before the
Court says that is a subject matter of investigation. Why should I reopen it?
no, reopen it every day.
Hmm?
But even though when the investigation will be completed, even though the charge sheet has to be submitted within 6 months. After 6 months.
You are seeking quashment of an FIR.
FIR,
The
right?
same FIR court says that it is a matter of investigation whether it was unlawful transportation or not. First. Second thing, the excise authorities are having jurisdiction to examine whether this is an unlawful transportation or not. So after investigation, if it is not unlawful, you are having document, you can transport, they will give a final report. And more particularly, the same matter is adjudicated. Why should we entertain this? And why should we not put a heavy cost for wastage of judicial time? We have to see the earlier judgment, nothing more. You file, you go to the division bench. Go against this finding that this is a matter of investigation. FIR may not disclose certain things, but investigation, it will be revealed whether it was unlawful transportation or not.
Again, in the concluding paragraph, it again says this repeating part of challenge. Says minor fingerprint. Concluding paragraph. Same issue was.
So this matter is having many controversies. And
Why was the land judgment not be applicable for one case?
will not give time for this matter before puja. Leave this matter after vacation.
পঠোৱালে স্কুলত আজি ভালেই হয়
So,
Standing item number 44.
Item 44. Huh? What happened to item 20? That bail matter, BA. BA or AB? You're supposed to allow. Yes, there was there, we thought that we'll allow it. Since not there, we thought that the session court or the trial court would have granted. Allowed. Bail granted. Item number 20, huh? Hello.
Item 44. Standing.
Maniklal Gwala.
This is the land of the future. It is pending with council. And the two degrees are obtained. And this was the 2010 second issue. This is the last petition that was almost the large of this kind of this second issue. Why is petition go for this cutting this out?
We do not know why.
This is the land of the petition. There is no modus operandi, there is no reason for cutting this trial. I can understand if there is some fire broke out in this particular.
So that execution process is simplified.
No, what is the question of simplifying the execution? When I'm getting by due process of law, why
You know, we know civil due process of law.
why should the petitioner go for all this?
Show him the case diary.
The photograph is, I'm not denying that. Cutting of the house, I'm not denying that. But it has been done with the petition. Because
Who else will do?
the informant herself, although I'm not very.
Oh, informant Halsel, because he has lost in court. Suit is pending. Suit is pending in second appeal. So therefore, to blame you, she
It's a
will.
matter of 50 months, like, you are getting a degree. And why should I go for all this new stuff?
Who has assured you that you are getting the degree?
So the last two, these two, on the last two occasions, the council for the petitioner did not appear, and once it was before default, not for non-prosecution. Thereafter, restored. So the conduct of the council, the conduct of the party is very much different. There should be some justification for cutting the trial.
Justification is she during trial.
The petitioner number 1 is the submission of prosecution. There is not 100%. Provide the investigation. Whatever restriction will be imposed, we will follow that.
We want to restrain you inside jail. So we'll record that the learned counsel has submitted that any restriction imposed is acceptable. So the restriction is that
Restriction is the cost of cancellation. Whatever restriction, the petitioner number 1 is the that can find it. The schools are one to cases who always fill up technical
Let us not comment more than rejection. Or do you want that we should quote what the independent witnesses have said? Rejected. The independent witnesses, as well, considering the fact that independent witnesses as well as the informant herself has specifically implicated the present petitioners in commission of the offence. Therefore, in the considered opinion of this court, this is not a fit case for grant of privilege of pre-arrest bail. Accordingly, it's rejected. Case diary.
49,
Yes. Perez pays. Mhm.
I'm not named it.
Oh, now people will name co-passengers names they should know, huh? To name you.
They are the prime.
Rejected. Don't expect that. Yes.
Consider the order of performance of next two things. That is the case,
Yes.
operating function.
Hmm.
By considering the rate of the prime accused, named accused, the honorable court made some observation. As per the case that is all implementing the material was against me. Please take to our house because we take loan from that particular bank. So we have some.
Now, what is the implication of this?
All the implication against the level of that.
You want to have my satisfaction of going through the scene. Okay. Not stated believing the additional public prosecutor, but to go through.
Yes.
Okay.
There is Pirazzi Madam. Mr. Person Madam, include account, the running was withdrawn and yes, deposited. And they came to he has a block file. He has also given it.
What is your name?
My brother, two persons are here. Abdul Ali and Abdul Salam. Two of the two is. So, madam, or maybe madam. Who get child account.
Hmm. What is your name?
Afsar Ali and Abdul Salam.
Hmm. All are involved.
All right. They use the Amazon and or something.
were very smart. We were coming by a train, they got information. But then also you could not be rejected. You are a team. You are a team.
For Postman,
You have now you have your satisfaction. I have seen it.
for Postman, that is 53 to 59.
Ah,
I need some time to prepare this after this. I have been.
that is
I have been
necessary.
in Calcutta for three times before this. Yesterday only. Tomorrow, Monday, Tuesday, any day continue to work. I have kind of some judgment for the first question, may not be completely covering the entire.
Wait for some time.
But you are-
He has come from Calcutta, now he'll be in Calcutta. Thursday? Thursday? Thursday.
Item number 60.
Just give us a way. We just act as an amicus.
Yes,
See, because this is creating a,
what, by now I could get a man that since one of the issue of.
we are convinced to an extent by Mr. Bora's argument.
Since one of in that case, there was no.
Yes,
issue.
you have a note.
Whatever sense of taking place, I got the point.
This is your responsibility.
So I would be trying.
It's a paradoxical situation for us. It's a paradox.
Sundarbhai Ambala, Nalok, this is there was no issue frame on the.
But what about the other
On the
case?
period.
Yes.
So to that extent.
No, there are other aspects. Okay, Sundarbhai Ambala, okay, we suppose assume that yes, Sundarbhai Ambala, no issues as well. Okay, was there any issue in the other case on 457? No.
That is why my division.
So division bench has passed an order based on two judgments.
Yes.
Two judgments. One is that earlier judgment for 457. So says that since investigation word is used, it is permissible.
Yes.
And in paragraph 34, quoted same thing. Whereas on its own, the division bench interpreted that there is difference between trial, inquiry, and investigation, and therefore not applicable. Now, which way should we go? So we'll have to have a way, and we'll have to have a clarification. It is having serious ramification. In my view, every day we are facing with this problem only. Many other cases are there where people are inside. We should concentrate on those. So finish it. We'll take a call, and you do give a note, and you also. Okay, on Thursday.
Item number 60.
Where is Talukdar? Oh no, this is something different. What was this sanction and all, na?
Not only sanction by the, not even go to like to put the sanction.
Hmm.
And the other one is the hearing,
Some magistrate has added some section.
first of all, magistrate has added the PCX.
PCX section, where is the jurisdiction?
Secondly, he has directed for the fresh investigation for funds. He only can go for further investigation.
Hmm.
Under 173A, only if concern is to be further investigation. But the de novo investigation doesn't only the superior court has the power for the de novo investigation. Here, my lord, first of all,
Are you enjoying a stay?
the one thing is that my lord, my clients, the large of my lord.
There was an IA for IA.
So that's why my lord,
That's why there is some
some
urgency.
address matter. very small issue, my lord, otherwise. There are two judgments, I'll refer it, my lord, to cover the whole. I'm not going into the sanction, my lord.
Okay.
Even I'm not going to be who's competent or not, because the IO who has conducted the entire investigation is not authorized.
Not authorized, it is a rank below.
And below. But even I'm not going to that. thing. Only two legal issues, whether the magistrate can add
Hmm.
the PCX section. First one was that there is judgment of our High Court. No. And the second one regarding matter the fresh investigation matter. The first one of here,
Hmm.
the FIR was filed
Hmm.
on 3/8/15. It is 60 PSD.
Where is that affair?
Base benefit.
Yes.
Possible file, page 23. The sections are there, 120B, 406, 409, 428.
Okay.
So these are the IPC section, my lord, initially. Then page 30 logic condition. Page 30, my lord.
Hmm.
Case record is put up before me. AMFC code is now vacant. It is in the prayer of submitted by the IO. It is the prayer to add section 713 of the Prevention of Corruption Act for prosecuting the delinquent official under the charges prayer is allowed. So we are agreed. We have challenged the issue order 24/1/17. Then the next, thereafter, my lord, I'll not go into that, my lord. The SI has investigated the entire case and the PCX, which is otherwise part, my lord.
That will take advantage during,
Yes. That is
if PC event continues. Yes.
because and there are judgment also that we have to show.
Please do this.
So I'll not go into that aspect. That the next is CS has been filed,
Hmm.
page 32. 31/7/17. Page 32 up. With other section with the PCX, 7 and 30. Page 30.
Page, I'm at page 32.
Yes.
Search sheet.
This is the charge sheet file.
Hmm.
So which
Well,
page
do-
34 is the relevant portion file.
Page 34.
So submitted charge sheet other section. So it should also along with the PCX, 730. So when there is a 713 file,
Where? That page 34.
yes,
During investigation, you examine so and so. But in papers, they had to completed account of salary. Read with section of the act. Okay.
so file of the
Hmm.
charge sheet was also submitted under the PCX
Hmm.
for the magistrate. Now, magistrate has taken cognizance of the PCX.
What is that?
That is on page 39. Last paragraph of the page 39. Cognizance are taken, last paragraph portion. Section, accused person 123, 406, 409, 420, read it section, 7 charging of the PCA. The magistrate has taken the cognizance of the PCA from this petition. Only the special charge is empowered to take cognizance of
What happened? Trial is commencing before whom?
the magistrate. Then, file next. Next lordship.
Mr. What to blame? To blame whom? Yesterday I got a case, 302 charge sheet file, exactly same order. Matter is under 302, magistrate CJM has transferred to self for disposal. In a bail application, I have issued a show cause. Why, under what authority that has been taken? Day before yesterday. Set aside, thus what remains?
Can be one more thing, my lord. 8/8/19, my lord.
Yes.
Next page, page 40. Page 49. That's more important. Now, page 19. The accuser absent with the state of 2020 part of absence paid for the another day. Our both sides of the petitioner, I have gone through the record. In there is some mistake on charge. As such, it appears that we did order in the field on starting point. And let the case record be sent to the office to reinvestigate the matter and submit efforts and charges after taking cognizance. The defense is directed for the re-investigation. This is not supposed to. He has only can direct for further investigation. Instead, is absolutely not effort for the re-investigation. So, again, CS has been forward. Now, CS has been forward after the re-investigation. So, these order has to go on. It cannot. And both the CS is the just the photocopy. But the
Now, what kind of order will we pass?
well, first of all, the heading of
Adding the section will go.
setting the section PCA
Go.
cannot survive. Taking cognizance by the magistrate cannot survive.
Under 7 and 13,
Cannot survive.
but other sections of magistrate
Remain.
tribunal that will not touch.
That order will go.
Hmm.
Thereafter, the order is the re-investigation direction.
That will go.
That will go. So, when the
Everybody, see, police also investigating officer, it is done by a sub inspector. He'll go to magistrate and say PCA, like that. All needs proper
And-
training, not
and-
only the
and
your authority, ours also.
therefore there is no sense. How the cognizance.
Give the judgments. Yes, that's what you say.
I don't have any alternative. Considering that.
This is a nullity. 7 and 13 from initiation to taking cognizance is a nullity. When it is a nullity, that portion will,
After from there itself.
from
everything
itself
goes.
it will go.
And the everything charge sheet will go by that.
Who has time to know that this will not cannot.
Cannot find. Please, yeah. Forget about it. Javjit Singh, if he was interested, he would have come.
Let me do, this is sub, then this is not sub at all. Tomorrow, that will give rise to another.
Mr. Bora, this is your mistake. This is your mistake, Bora.
I'm not giving it expired. If it's theoretical, it is then better.
Where?
No matter. Now I will have come to know. Because after.
See, argument is over. You have not even taken step.
we have taken steps.
See, you have taken step. There are two directions. One is through registered post, other is usual mode. Since you made a party, notice is issued. At the moment we start the dictation, see, notice could not be issued upon the respondent number 2 through the district magistrate due to non-receipt of step by the section till date. Yes, so all half-hearted. But the direction is two ways. Even if he is expired, file an affidavit, give us something. Of course, these are technical things, but there are orders, earlier orders to issue notice. Even scan copies were not required, but that is there. Okay, fine. See, you brought the senior advocate to argue, and you are not even aware that you have not taken steps. When will you file? Huh? File it. List this matter on. Steps is not complete. How can it be? Here is his completed, but see, this is not expected, at least from a person having that much of practice. Why are you so casual? Well, it's your fault. Why are you so casual? No, we will not keep it as further. List this matter on Thursday, not Tuesday. If you file an affidavit, you file it on Monday. Otherwise, his presence may not be necessary, maybe private, because in view of our High Court rules and Jagmeet Singh, according to me, is that it's his right. It's his right. If he comes, he has not come. He must keep an eye. But problem is that you have made parties, there is a direction to take steps 2 ways. Can I now ignore it? Okay, forget about it. It is a special case of Mr. Mr. Bora, so we will not do this. 19th. You file whenever you file. Leave this matter on 19th. It is submitted by Mr. Bora that the informant has in the meantime expired. He may file an affidavit to that regard in the meantime. Mr. Bora, can you give me the judgments?
I've already.
Huh? Okay, so that on next date I can come prepared.
61.
Yes. Office note dated by Sengi. No. In terms of 12/9, nothing has come. Registry to, huh? On 28 August, there was an order. Then it was issued. Statement including the seizure list. Everything is there.
I did not find 161 statement.
161 statement is not there.
That is not the today one is found 22nd of August.
You are correct. The scan copies directed to be produced in terms of order dated 22/8/2023 has not yet received. Full stop. Registry to issue reminder for it. Yes. And leave this matter. When? Any urgency? After vacation.
So many cases.
So many cases are pending. Okay. After vacation, give a date. And from next week onwards, there will be huge about bail and all. When? You can take a chance, but we will not be in a position to give a date around 26, 7. This It will take time, that's why. And next date will record will come, then we'll have to go through it. After vacation is the best proposition. Give a date after the day. 8th of November.
63,
Thank you, Lord. So last of it is better to apply to some of the things that was directed to students to American movie level.
Ah.
Okay.
This is the case of the section 17A, you know, that don't comply to section 17A of Prevention of Corruption Act. That is what is
Yesterday I wanted to make that this is not applicable to this case, but it's not aware. But this could be any recommendation or this is taken by the because the accused has demanded the job office having.
Just recall, everything is gone. I have forgotten everything. What is the case?
You know, the case of the prosecution, there are two officers of my department.
Mm.
First, got credit.
Mm.
That is dated, dated on 12th of June 2020.
Mm.
And the person who was doing the price was also
What is the stage now? What is going on?
Consideration of charges.
scrutiny of documents.
Charges has been filed, all the documents which is supplied to the now this can be for consideration.
Can we raise these points during
I
service?
will satisfy this on the.
No, that you can satisfy, but why are you, suppose we close it, this is your end of this your road, you cannot go back.
No, as far as this aspect is concerned, this is.
Why are you not having the faith on the CBI
No,
court?
I have definitely I have got a faith in the CBI court. My only hate change, it will take me a lot of time and 2 years will lapse. And in the meantime.
No, framing of, cannot it be decided during a
I'm a senior officer, my promotions are due and I will be,
promotions will be kept in the seal cover.
No,
That will be given you immediately. For that, should we give a preference to this matter?
If my lord may give me 15 minutes, I will satisfy the honorable court.
And give no preference to the item number 71, 72.
No,
Today's-
I am not seeking any preferential treatment. I only seek 15 minutes of my last time and I will conclude my lord in that 15 minutes. If my
Your
lord is not-
15 minutes and this brief and to reply and to pass a judgment will take 15 days for me.
No. These two are.
Ultimately, it's a case of discharge.
No, ultimately it is of course a case of
Discharge, is not it?
My contention is, the parliament in its wisdom has specifically inserted this provision. Article 21 says, my life and liberty cannot be taken away without following the due process of it.
Yes.
And the due process is followed, the constitution, though there was protection under section 19 of the Prevention of Corruption, how still despite that fact, the legislative.
Yes, section.
The section is not applicable to this. I will.
No.
Now,
Now tell me one thing,
yes, my lord.
whether sanction is required or not,
Yes,
can be decided on the next date.
sir.
What is the next date fixed?
Today, we can decide it today itself. Lord.
I think 18.
Huh?
18. They for consideration of charges.
Then
No, my lord, my respectful humble submission,
see, we are not shying away from doing cases.
Yes, sir.
But problem is this. These are not the cases we should give preference. Where you have having a remedy to argue and come back to us.
There are two aspects. One is.
Is it not? Can't you raise all these points before the, tell me. Is it barred? In the next date, this is it, next date is fixed for framing of charges on 18. Can't you argue all these points before the CBI? So that we can apply our mind on the next date, saying that yes, the CBI court has committed wrong or committed right.
I will have only one thing. I have a remedy for that remedy, I will not that the remedy expedited because However, I will satisfy this honorable court that this is a case for exercise of powers and the second for 82 law. Because the prosecution for this man, well, I'm not saying that against those officers or other officers or other persons it is not. But who are these officers is rescued and abused from.
Your case is that sanction is required.
No, but my case is beyond that. So I had two cases, two different versions. One is that there is no allegation that I have accepted or taken part. Or that the crime was accepted for on my behalf. I will be out of the court with my letter friends here that the 4 lakh rupees that was taken by the allegedly taken by the officials of my authority were taken for or on my instruction or for my behalf. Or that money was given for me. If I will be out of the court, I will not even hesitate for even a second. But the issue is, that money was not, neither was for me, nor was given to me, nor at my instance, or nor for my instructions. Now, if that was the case, and what is the case, that I allowed each bank company or the company release by actually in exercise of my office. In the powers vested with me in due diligence or I exercised my powers and I allowed and ordered release of bank guarantee. 2 bank guarantees were released. If that is not that power I was exercising only in discharge of my official duties and kindly see for a minute, section 17 for a minute.
Appreciate.
Section 17 says that no police officer can investigate the offense. If the offense is related to any decision taking or representation made by public servant, in which are officer duty without the prior sanction of the government.
No, absolutely right. Under section 17A was specifically inserted in there. And it was inserted with effect from the
26/7,
6/7.
2018.
There were compelling circumstances that the legislative court that despite the fact that sections of prosecution and section 19 and all these sections were available, despite that, they inserted. So we not add on that day when they arrested me.
Okay, show us the allegation against you.
Allegation. Yeah. FIR, I am not arraigned as an accused. No,
Okay.
I am not arraigned as an accused in FIR. In the charge sheet, on 22nd, 12th, kindly clear with me for a minute. On 12th, they arrested 2 officers taking bribe. And the person who was giving the bribe. They prepared a detailed bribe proceedings, where memo and everything was prepared. None of those 2 officers who were arrested had made any indication that this was meant for. Or none of the person who was giving allegedly got giving the money had stated that this money was for. I was not involved in any of that project. Now, on 12th, they arrest these 2 officers. 13th, they complete their proceedings of Panchanama and everything. Detailed Panchanama, memo is prepared. None of, there is no whisper that this money was for me or for all my instructions. It was accepted or taken. Now, 13th goes on 14th they arrest me. 14th they arrest me. There is no confessional statement, no confessional statement recorded thus far of any of the court news that any money was belonging to me or recovered was meant for me. Now, so therefore, it cannot be said by any stretch of imagination that this transaction of taking or receiving right was for me or at my instance. Now, they say in the charge sheet, kindly see, I had like charge sheet with my petition member. charge sheet starts from the page number 35. Allegations start from page number 47. That it was the way that business we are into a project limited awarded that the whole construction tender with the jurisdiction of NHI regional office, Guwahati, and Shri Sushil Kumar Batla, manager that from the project director, he is monitoring the project work. According to Sushil Kumar.
You need not read all, you tell us what are the allegations against you in the,
Education that I exercise my power and I allowed to be used to the region.
where is that? Where is that allegation?
Yes, sir. Kindly think about page number 57. Para number 1620, investigation disclosing that since 1/4/2020 to 2000,
Where page?
page 57.
Yes.
So, on page number 57, serial number release of proportion paying guarantee amounting to rupees 4 crore on that is on 27/4/2022. And the release of performance bank guarantee amounting to rupees 2 crore 58 lakhs. That is on 9/6/2022.
Hmm.
These two bank guarantees are.
Now suppose sanction is not there. What is the end result?
And
Everything gone.
proceedings for me are void ab initio.
Then can the sanction be taken up subsequently?
No, my lord, this is not, my lord, this honorable court has dealt with this issue. They say you cannot, I have judgment, my lord, in which this honorable court issued direction to the CBI for the registration of preliminary inquiry and carry out investigation inquiry. Then, my lord, CBI is under its direction from this honorable court registered case after carrying out the investigation. This honorable court revisited and directed that no, you cannot do despite the orders of the ours. Despite the orders of Honorable Guwahati High Court, the CBI could not register the case because the proceedings will be void ab initio and directed them to apply to the department concerned for the permission to investigate and carry out inquiry. Then, my lord, on page number 61, my lord, besides that, there is no allegation again. Then page number
16.30.
16.3. Then investigation disclosing that.
So except this, there is no allegation against you.
Then, my lord, there is another allegation in under section in para number 16:32:36.
Yes.
On page number 63. That with regard to the reward being time of demand and acceptance of bribe by accused public servant working in NFA, people task to so. But for recommending the favorable report from the site office, timely processing of the file of the bill, payment of the PB release without raising any objection, and payment of bills and release of PB at NHI regional office, Guwahati. Lord, as far as this is concerned, Lord, I placed on record document of NHI, which says that the release of bank, besides the release of bank guarantee, I had no role to play as far as supervising the work for which, Lord, there were specific authority engineers were appointed at a cost of 9 crore rupees. And, Lord, they were to monitor the day-to-day functioning. As far as the clearance of bill is concerned, Lord, I had no role to play. Clearance of bill was to be done by the project director, Lord. That was subordinate officer, and that was not my task, Lord. My responsibility was only to see the release of bank guarantee on the recommendations of the project director as the recommendation of. recommendation of the third engineer. And 2 minutes more for them, Lord, I to make 2 more submissions. As per the contract entered between authority, between the NHL and the contractor, Lord, it was the duty cast upon the authority to release the bank guarantee after completion of the contract period. Contract period had ended on 31st of March 2022. And the bank guarantees were released subsequently as demonstrated in cell number 1620 of the charge. They were subsequent, and it was provided in the contract that it will be released within 60 days of the completion of work. Furthermore, Lord, the penal interest was chargeable on the authority. And Lord, under these circumstances, prior to this also, the authority chairman has issued directions. Only one letter.
How to buy a branch, how to the sector. And it was the all industry problem, the consumer of the industry. What is the net your
First sample or what?
question? What is the industry problem question? What the industry problem? Transcript of the industry.
Mr. Council, it will take some time. Not possible, not today, not possible. Give a copy to him.
Today, and because I will go read it 5 minutes, 10 minutes.
No, it's not a case of 5 minutes. 5 minutes you can complete it. I don't have that much of capacity to write a judgment, either dismissing or discharging in 5 minutes. This is not a case. You go there, will pass that order.
I will satisfy this honorable court.
We are not satisfied. Why should we waste our time here?
It is absolutely no case against.
So therefore you will be discharged by the learned court.
That is not also the difference jurisdiction law.
Why? Why the date for argument for charge is fixed?
So your 482 is for the purpose that if the proceedings are.
Will not go to all these factual aspects in 482.
This case also, section 17 means no applicable. He is not disclosing the.
See, on last, you are sitting here. We wanted to exercise our power under 482 in a case where there is no jurisdiction and proceeded. That is a different case.
Jurisdiction itself is.
Here a question is that there are specific allegations. They have intercepted.
By intercepting a call note, what is the content of the call note, that is important. I have not seen.
Can we decide all this in 482?
What at all.
Can we decide that no, this is the intercepted call or this is the statement of witness, this is not believable?
Whether only 4 questions are.
Only suppose if it is only a case that you have been made an accused only for releasing the bail bond, bail bond, that is bank guarantee.
Yes, sir.
But along with the allegation is that you have taken illegal gratification
In form of loan. Not even single penny loan.
Any is the.
in form of getting some benefit for some of your near ones and dear ones. That may not be correct, but they took some statement of that person also. He said due to your interference, they want to link that this Lena Dena is there. Now can we say no, this was
My prayer is, my Lord, will see. I have confined myself only to the issue, whether it is case of section 17A, whether they have been required to comply with the provisions of section 17A. But I have not gone into the merit or demerits of the case, Lord. It is not even, I have not even made that awareness in the my petition. I have confined it to, not whether, see, what they have done is, they have not registered case against me per se initially. Now, without any evidence, without any statement of the any of the court, they have arrested me and arraigned me and accused in charges. Despite the fact that after thorough inquiry and investigation, they have registered an FIR. In the FIR, I am not named.
today it will not be possible.
They are making fix any date.
Today it will not possible.
Section is very clear, 17 is.
I will-
offense,
maybe my Lord will have-
decision and recommendation.
I will find-
There is no recommendation made by this person. Neither there is a decision, nor there is a recommendation. He approved the bill. There is no recommendation. Rather, the evidence that he demanded. The.
No, approval of a bill may be a part of his job.
Yes. We are not denying that.
Then, so can you confine it to that extent that approval and thing will be?
Yes, our present chief justice also has occasion to deal with this issue while he was High Court, and he had 2 judgments.
Not today. Not possible. You are in midst of some other hearing.
I don't.
How many judgments is possible to pass in a day? Tell us that first. After taking 70 bills, how many judgments you expect to be delivered by a judge on a day?
Because our Lord court was registered.
Give a date.
While maybe punching out only 2 relevant clauses are there.
We are not taking up it today. Give a date
Yes.
as per your convenience. When?
Any date coming to my Lord, for those criminals.
Give it on 27th. 27. Then give, huh? Huh? Uh, 5th of October. 5th of- huh. So that we can come prepared reading this. Yes.
Timing
Just keep the judgments inside the file. Mr. Bora, we are sorry to say that somewhere I advance your judgments, but misplaced it. The judgment you relied in this case. Some judgments you relied in this case, no? Somewhere I advance, two judgments, What was the, how on Delhi High Court, what was those? Are you having extra copies? Mr. Chaudhary, are you having extra copies? Or if not, give them, they will give us the Xerox. One is
for the Delhi High Court,
party's name,
2008. 2008 FCC online, Delhi 711, Bhupinder Singh Patel.
somehow I took for going to it, but somehow I missed it. Okay, give the judgments. Yes, Mr. Talukdar. So, Mr. Bora will have to argue FS, you were not there on that day. You do one thing. We are coming back at 2. Give the judgments in the meantime. In the meantime, during the recess. Right now. At 2, we are coming. Oh, we'll finish it up this matter. If possible, in the dictate itself. Then we'll go to the other hearing matter, some hearing matters. This is the admission last, no? First month. Any admission? No. So thereafter hearing. So we'll conclude this, then we'll go to the hearing matters. Give the judgment.
K-pop. K-pop. Or K-pop. Yes, people are used to, you know, it's the I need to see it. K-pop. I think
Interview was fixed on
5/8/15.
5/8/15. He appeared.
Here.
Hmm.
So there is a talk. Something regarding the-
Some he made some person said that you will not get the job until unless you pay money, something like that.
Then my lord,
He was asked irrelevant questions. You
so
okay.
October 15,
Hmm.
he paid 50 lakhs
Fif-
as a price.
fif- 15/10/20.
Okay, this only the month. The
Okay.
month of October 2015,
15.
he paid 50 lakhs as a bribe amount.
50 lakhs or 50,000?
50,000.
50,000, I think.
So,
At Satsanga.
for that course. And this has been admitted into his FIR.
FIR 161 statement.
Will be also in the evidence.
In the evidence, yeah.
That we paid 50 lakhs. 50,000.
FIR was lost on which date?
FIR was substituted on 17/8/17.
17, 8, 17. When the result was declared,
Result was declared on 4/2/16.
4 to 16. And there was something that 50,000 will not be sufficient, we'll have to pay something on that.
But
Ah.
he has whatever,
Hmm.
and his name did not appear.
When result was declared on 4 to 2016.
Yes,
Hereafter on 17/8/2017,
17.
he filed the FIR alleging that 15,000 paid on in the month of October 2000 at Satsang.
Yes.
And the interview was held on 5/8/2015. So if we go by the sequence, interview was held on 5/8/2015. He made in the month of October 2015, paid 50,000 at Satsang.
Yes.
Then result was declared on 4/2/2016.
Yes.
When he was unsuccessful, FIR was lodged on 17/8/2017.
So, after 1 year, 10 months. Now paying the price now.
Hmm.
So
Okay.
all these years, my lord,
Hmm.
he was absolutely fine.
Hmm.
So he was just he was waiting.
Hmm.
So that means
Hmm.
his intention was very clear.
If he would have gotten the job, he would not have filed the
Right.
appearance.
So admittedly,
Hmm.
when he paid the money, there was no proceeding was pending. No proceeding was pending.
Okay. Because under section 24,
So
so statement should be made in a proceeding.
Yes.
And according to you, on
when the FIR was filed,
your
and then prior to that event,
Hmm.
when he paid the actual amount,
Hmm.
at that time there was no proceeding was pending.
Okay.
Then on the basis of his FIR, the processor initiated investigation, initiated charges were paid. Then his evidence was recorded on 31/10/2023.
What you have said? His
His evidence,
evidence when?
31/10/2022.
Okay.
31/10, 1/11, and 2/11. 3 days completely.
Yes.
Then on 2/11/2022, we filed a petition.
You filed the petition.
I filed a petition on 3/19.
To making him an accused.
To make him an accused because when he paid the money, at that time there is no proceeding was pending. He ought to have been accused in this.
So according to you, on the date of payment of his bribe, in the month of October 2015, no proceeding was pending.
Yes.
Therefore, such FIR cannot be treated. So therefore, we will not get the benefit under section 24. This is your case.
That's fine. So at the date of FIR also,
Hmm.
there is no proceeding. And he admitted himself that I paid the money. No proceeding.
Investigation started on 17/8/2017 cannot be treated as a proceeding.
Yes.
Cannot be treated as a proceeding because proceeding has been defined under
Fine indeed.
in some action or disorder.
Otherwise, the now we have filed the prosecution also filed an objection by the
What was the stand of the prosecution?
prosecution that this copy is covered under section 20. So now the trial court by the special judge imposed a cost on me of 10,000.
Hmm.
My order it is 5/11/2022, my lord, page 73. Also, Lordship can see the observation. made
Impugn
by
order is space.
Page starts from my lord, page 68, my lord,
Hmm.
and the relevant portion is the page 73. The bottom page line.
The date.
The day
Hmm.
on which. As a lordship,
A date of occurrence in a
The
criminal case is the day
yes,
on which.
the day on which the informant deposed in the during the court during the trial cannot be the date of occurrence. As informant was protected on the day of payment of illegal debt. How he is protected by the on the day of payment of illegal debt? At that time, there was no proceeding was pending.
Hmm.
No FIR was there even.
Hmm.
How the trial court come to the finding that the informant was protected on the day of payment of illegal gratification under section 27 of the PC Act, his protection will continue on all subsequent dates. That protection is only available during the proceeding. And the learned trial court gone beyond that, even not even taken the date of filing of the FIR. As per the trial court,
The date of occurrence.
on the date of occurrence, on
Occurrence,
when he
that is-
paid the money,
That is October
October
2015.
on that day onwards, you are protected. How it can be minus is protected? On the day he payment made the payment, no proceeding was pending, nothing.
Okay.
So how he is protected, my lord, under section 20? That is our case. His intention is apparent. He was waiting for the result. His intention is apparent. So now, the intention is very much important in this case. So Supreme Court, in the judgment while dealing with the section 24, say that his intention is very important. Only for the public good. He will not do that public good that if he has paid the money for the public good. He has to satisfy giving the time. If he has done it. Only simply saying that I made the payment. But here, while he made the file was subsequent. It can't be even the public good when he takes the money. Because for his own wisdom and he has paid the money for his own benefit. At that time, and he has waited for 1 year.
So you want to say, had it been a public good, he would have informed the police, then he would have went to give the
He
money.
should have, first of all, either he should have given a prior information to the police that the money has been asked to me
Or
and I am
immediately.
paying, or immediately after payment. Please, he should have come to the police that I have paid money so and he asking for the rest of the money. But the only case is that whether, first of all, he is protected by the section
Section
24.
24.
Now, the Supreme Court, while dealing with this provision, there is a case by the Delhi High Court where the sting operation was conducted by some of the journalists.
Just give me a minute. Just give me a minute.
So his apparent conduct is that
Hmm.
अगर मिल गया तो राम राम
Hmm.
और नहीं मिला तो राम नाम सत्य है. And surprisingly,
Hmm.
the prosecution
Hmm.
is protecting this kind of, I have never seen. The prosecution is trying to protect a person who has admittedly paid the money. Years back when the trial even started.
Yes, which judgment you want to rely?
The first judgment I want to rely is the High Court judgment.
Hmm.
Delhi High Court judgment, which is the subsequently
Bhupinder Singh.
Bhupinder Singh, that should be some of the accusers subsequently challenged.
Hmm.
Because the framing of the charge on the basis of against the framing of charge by the six accused person.
Hmm.
I'm not going to be direct to the facts, but facts are not very important. But the paragraph 48 is very important in this case. And so, just for the lordship,
Yes.
just I'm just in the cross examination in this case also,
Hmm.
yes, categorically stated, as I could not secure the job,
Hmm.
I had lost this FIR after release of the selection list. That is the cross.
Pace.
Page 58 minutes cross in my division.
58.
I'm not on asking, but the for the lordship.
Okay.
And tell you this, that what was his intention that is apparent, because the intention is very much necessary to deal with section 20. Now, the paragraph 48 of the Delhi High Court. The section 24 of the State Act comes to the rescue of the such person, public right, who makes a statement in any proceeding against a public servant for an offence under section 7 to 11 or under section 13 or section 15 of the Act to the effect that he has offered or agreed to offer gratification other than the legal remuneration or any valuable things to the public servant. In such cases, the statement cannot be made as to the basis of the prosecution of such person for the offence of abatement under 12 of the State Act. The section 24 of the State Act reads as under.
Okay.
Statement by the bribe giver not to subject him or prosecution, not to extending anything containing the law and time in the court. A statement made by the person in any proceeding against the public servant for an offence under section 27 that the offender agreed to offer any gratification other than the legal remuneration or any valuable thing to the public servant shall not be subject to the such a person to prosecute under section 12. Now,
Yes.
now, subsequently minus B part 1 thing.
Hmm.
Section 24, apart from the proceeding,
Hmm.
there's one more requirement.
Hmm.
Is when he is protected. He is only protected as far as my humble submission that he offered or agreed to offer
Hmm.
any gratification or any valuable thing to the public servant. That means not the payment, only the offering.
Offer.
So if I offer to a public servant that I'll pay you, and if I admit it in the proceeding, so legislature.
So according to you, it is only it should only be offer, not the actual
Payment.
action of
Yes.
or payment
Yes.
of delivery.
That's Because the legislation is very clear. If you make the offer, only offer will not do. Offer is protected, but if you make the payment, you are not protected.
Okay,
Because of this kind of situation, this legislation is very much aware that this somebody will definitely will pay the money and he'll wait, and subsequently he'll get the protection under Section 24. So here it's not the section. He has rather paid it. Not only the offer, rather he has paid it the money. So his offense was complete.
Hmm.
So in that case, he is protection. So there are twin condition for the protection. First of all, it has to be a proceeding under which his statement is protected. Second one, if he simply offers, not to make the payment. Otherwise, he is not protected. That is my only. So, in second one, may I read it again, Madam now?
yes,
Under section 2, it may be noted that whenever a person lodges a complaint with the police that he has been asked to give bribe, which he is not willing to give, his statement is recorded. Upon the registration of the FIR, an investigation is taken up, and if so required, a trap is laid. It is during the investigation and the trial, the complainant is required to make such statement, and such statement, it cannot be prosecuted for the offense of abatement under Section 8. Section 24 of the Act does not envisage blanket protection to the bribe giver. This is very important. Bribe giver. So to the bribe giver, there is no protection at all. Here he is a bribe giver, my lord. Offer would have been different. Under all circumstances, the immunity for the bribe giver is provided when he is unwilling to pay. The illegal gratification to the public servant, and if he approaches the police agency, in order to get the public servant there while accepting the bribe. That is why I am saying that the offer is one thing and the paying money. The moment you make the payment, you are not protected. Only Section 24, if you want the protection, you cannot pay the money. The moment if you pay the money, you are out of that protection. Apart from the proceeding.
then you become an accused,
Yes.
not the savior or
Because you have already because simply offering it we can understand, but here it's not a case of offer. Here he paid the 50,000, he waited, when he not successful, then he after the 10 months will not give back. So if he is only willing, then he is protected. If unwilling to give, his statement is recorded and he is protected. But he has to say that I was not willing. If petitioner was neither the police officer nor any authorized by any carry out the investigation, therefore it cannot be held that they were conducting any proceeding, which is very important, under this code. So here, the journalist who has paid the money, my lord, in this case, in the sting operation, they were not conducting any proceeding. Neither this man is also not conducting any proceeding. He simply paid the money. The basic requisite of the applicability of Section 24 are not made out, and therefore
you want to say, suppose had it been a case that he even paid, but after informing the police,
Yes.
then it would have been, and his statement recorded would have been
Yes.
maybe under proceeding. Because statement in during investigation in terms of this judgment you relied on is also treated to be an proceeding.
I'll come to that. Yes. So, as per the my submission, it is not also proceeding. But even that, if I take it to be that the FIR is a proceeding,
Hmm.
then also he's not covered. Because the moment he has paid, the twin condition is not, because at that time there is no proceeding pending.
Hmm.
And secondly, to get the relief under section 24,
Hmm.
he can't pay the money. Only the offering at best,
Okay.
then he is protected. The basic requisite applicable to section 24 law may not therefore be raised by the accused, including the accused number 4 and 5 are they are entitled to seek protection under the raised instructions which does not hold good. So this is the now that has been challenged before the Supreme Court pilot.
Hmm.
Now the Supreme Court was the observation of the Supreme Court is very important. Paragraph 18, 19, and 20.
Hmm. Just a minute. Yes.
Paragraph 18. The sting operation conducted by the law enforcement agencies themselves, the above jurisdiction, has not been recognized as an absolute principle of crime detection and proof of criminal act. Such operation by the enforcement agencies are yet to be tested in India. Even this sting operation by the investigating authority also not been recognized by this court in India.
Hmm.
And legal acceptance thereof by our legal system,
Which paragraph you are reading?
paragraph 18.
Oh, I was.
Does-
Okay. I was in 19. Does.
Thus, the sting operation conducted by the law enforcement, even the Supreme Court says, even the sting operation carried out by the law enforcement agency is not accepted in India for proof of criminal act. The operation of the enforcement agencies are yet to be experimented and tested in India, and legal acceptance thereof by our legal system is yet to be answered. Nonetheless, the question that arises in the present case is what would be the position of such operation if conducted by a state agency, not by a state agency, but by a private individual, and the liability not for the principal offender uninterrupted into committing the crime, but of the sting operation as staying his own hands by entrapping what he considered to be the main crime, what to be considered main crime and a main offender. Should such an individual, that is the sting operator, be held to be criminally liable for commission of the offense that is inherent and inseparable from the process by which the commission of the another offense is sought to be established. Should the commission of the first offense be understood as a obligated and extinguished, to be obliterated and extinguished in the face of the claims of the larger public interest that sting operation seeks to make, namely to expose the main offender of a serious criminal injuries to the public interest.
Hmm.
Can the commission of the initial offense by the sting operator be understood to be without any criminal intent or only to facilitate the commission of other offences by the main culprit? It is and its exposure before the public. These are the some of the ancillary questions that arises for our answer in this present appeal, and that is at the threshold of the prosecution, that is before the commencement of the trial.
The answer to the above, in our considered view, would depend, as in criminal cases, on the facts of and the circumstances thereof. A crime does not stand obliterated or extinguished merely because its commission is claimed to be public interest. Any such principle would be abhorrent to our criminal jurisprudence. At the same time, the criminal intent behind the commission of the act, which is alleged to have been occasioned, the crime will have to be established before the liability of the person charged with the commission of the crime can be adjudged. The doctrine of mens rea, though a salient feature of the Indian criminal justice system, finds expression in the different statutory provisions requiring the proof of either intention or knowledge on the part of the accused. Such proof is to be gathered from the surrounding facts and established by the evidence and the materials before the court, and not by a process of proof of mental state of the accused, which law does not contemplate. The offence of arrestment of the fine under section 107 IPC or the offence criminal considered under section 120 IPC, which does require a criminal intent on the part of the offender like any other offence. Both the offences would be required existence of the culpable mental state, which is a matter of proof from the surrounding facts and established by the criteria of the court. Therefore, whether the commission of an offence under section 12 of the PCI, even section 120B of the IPC, occasioned by the acts attributed to the appellant accused or not, ideally in a matter that can be determined only after evidence in the case is brought. That the appellant accused asserted is that in view of the fact that the sting operation of this journalistic exercise, no criminal intent can be imputed to the participant therein. Whether the operation was really as an exercise and giving it to a bride, accused number one, was a mere shame or the pretense of whether the giving the bride was an exception of the favor in connection with the mining to the question that only can be answered by the evidence on the party, which is yet to come. Such that cannot be matter of an assumption. While the present case, there is a long gap of nearly 12 days. In my case, 1 year, 10 months now. Between the operation and the circulation thereof, the public is another relevant feature of the case and would require examination. The inherent possibility of the abuse of the operation and videograph, namely the retention and use of thereof, ensure delivery of the favor, issued the receiver of the bride has to be before the liability can be attributed to. This can happen only after the evidence of the witnesses is recorded. Also, merely because the charge sheet is signed and the accuser undertaking the operation against the political matter cannot be undermined the importance of the proof of the opposite text to draw the possible and the conclusion on the basis thereof as regards to the criminal intent of the accused in the present case. An issue that has been on behalf of the appellant that will be finding with regard to the culpability of the accused even prior to see would be detrimental to the public interest because as the opinion of the court would have in habitation of the enterprising to success journalist and its opinion of the carrying out this thing of the corruption and the other illegal activities. The matter can only be viewed with difference. The journalist or any other whose no connection even remotely with the favor that is illegally sought to be exchanged for the bribe offer cannot be imputed with the necessary intent to commit the offence or abatement under section 12 or the consideration under section 1. The non-applicability of the opposite provisions of the law in such situation, therefore, may be expressly affirmed. The cause of journalism is the role of the responsibility spreading to the information awareness to be observed. It is not only the case where the question of reasonably arises whether the scheme operation has a stake in the favor that the relative short in return for the right that the issue is not require determination in the course of the full credit trial. The above is certainly not an explicit and the situation that is in. So, the Supreme Court,
Yes.
as per the judgment final, says that the protection, he has to gain that protection during the trial, not before.
Now, You relied on something to say what is a proceeding.
Yes, I have relied on judgment, my lord, and on the last proceeding, I have two things, my lord, on the Black Law Dictionary, I have relied on.
Black cloud is.
What is the proceeding meaning, my lord?
The judgment is inside that book. In my drawer. Huh? Twitter lens.
So, my lord, 1982, 186, 525. The meaning of the proceeding has been defined by the Supreme Court. And the Black Law also both defines that the proceeding it has to be in the court, judicial proceeding inside a court.
The proceeding is not defined in any of the CRPC or
Direct to
not defined.
only the initiation of proceeding has been defined. Based on a chapter, my lord, Dr. Mali, that would be
CRPC.
here. Chapter 14. my lord.
CRPC. Okay. CRPC which provision?
Chapter 14, my lord. Now, my lord, the one thing of the only can is the definition first also.
Definition.
Section 2. Before I go to the chapter 14, my lord.
Section 2.
Section 2, 5.
I.
Judicial proceeding includes any proceeding in course of which evidence or may be legally taken on oath. That means 164, recording of the 164 is also a proceeding. Because that is recorded under oath. Anything under oath or otherwise, the evidence which has been taken. So, while the FIR was filed, and when he paid the money, at that time there is no proceeding at all. And the next, my lord, you will find the chapter 14, section 190. The heading of that section. Chapter. The condition requisite for initiation of it. Chapter 14. So where from it starts, my lord? It starts from taking cognizance by it.
Yes.
So, my lord, our contention is that first of all, the statement during the course of the trial is protected
But
up to a limit.
Hmm.
The limit is that I have offered up to that limit. If he made a statement during the trial or under 164, because 164 is under oath. So in that case, yes, section 24 is for his protection. That yes, I have offered the money to so for this purpose. But if you process that boundary, so there is a boundary.
and actually
He
pays,
pays the money,
then he's not,
then
he's
he is
not protected.
out of that boundary. So up to that boundary, till he offering,
Hmm.
he is protected. And he makes a statement during the 164, or he comes to the court, he poses a witness that yes, I also offered this man for a particular job. Then he is protected. But section 24 says only that. But the moment you pay, you are not protected. Protection, the payment, after payment, you are not. So, my humble submission is that, and we are not only his 330, even the his. If we consider that his statement under the court in the trial is protected. Suppose, let us assume it that it is statement under the oath. He made a statement under the oath
During this
During the
testimony,
trial.
right?
during the trial, so assume it is protected. But what about his payment prior to the trial? Is he protected?
That according to you, that
That part is
prima facie shows a cognizable offense. So he ought to have been
made an accused.
made an
At that time, it's, and even if, my humble, that even the filing of FIR even, not a case, not a judicial. It has to be undergone. And during the business transaction of during the course of the court proceeding. As far as the black law is concerned. And the chapter 14 is very clear to that effect in the CRPC, where from the proceeding begins. The proceeding begins from 190 when the magistrate takes the cognizance of an. And our second part is that in his deposition in the court, he has rather admitted that he paid the money. Not in the FIR also, even in the deposition also, he has admitted. So moment he paid the money, you are not under the protection of the law. Offering would have been different, but in his evidence, he admittedly said, I paid the money. So he is not protected. And the second limb of my argument is that if you are protected also, then also you have to face the consequence of the trial. You have to show in the trial what the Supreme Court said, your intent. You have to face the consequence in the trial, then you have to rebut during the trial that you paid the money for the betterment of the public at large. There it is your duty. That's that. And there is not a blanket protection. That is the Supreme Court. And the High Court, Delhi High Court, the same judgment, which is one of the Supreme Court. The blanket protection you are not getting. Even section 24 also. You have to face the trial. In the trial, you show. By cross-examining the witnesses, you can show that the mind, because the intention was to for the better public cause. Not other. But here what? He admittedly said, I paid the money for my own job. And because I paid the money, because I have not, I lost the FIR because I have not got the job. So this intention is very clear. So he has to face the consequence. And I don't know why the state is protected. I don't know why the trial court is protecting. And the trial court has gone beyond his jurisdiction, even protected him from the date when he paid the money itself. That his protection continues from the date of payment. So proceeding as per the trial court, proceeding has started when he paid the money itself,
Before lodging of the FIR.
before lodging of the affair. Absurd.
Okay. Yes,
This is that cannot be measured tomorrow because the logic is there. Otherwise, each and every person will do the same thing. I'll pay some amount to the somebody and I'll wait. Okay, I'll pay the rest of the amount the moment I come. Everybody will take the that simple. Then thereafter they will come to the court that we are protected because we lost the FIR. The moment you will not get the job, you lose an FIR and you say, no, I am protected because I have lost the FIR, so proceeding is pending, I am protected under section 50. It cannot be the intention of this. Legislation is very clear. The moment you are paid, you are not protected.
that's why according to you, that's why you, what
Because it's
offer
offer.
is.
Only the offer. Not beyond that. That's very clear from the judgment.
Yes,
my-
who will add anything?
That's all.
Okay.
We feel.
Who will add this first, PP or you? Hold on. Okay.
Here by the forest things mother carries the
Hmm.
This the place.
Hmm.
Yeah, since when the FIR was lost. And when this year has been submitted. And the supplementary subject. Thereafter, the issue number 8, the median number. The supplementary subject number 4. That is on 4/7/2000.
Where?
On the first page.
Okay.
These are the date of probability.
He is already accused
The
in,
median number and the supplementary subject 4. That is at row number 1, 2, 3, 4, 5, 6 number. 4/7/2019.
that I have seen.
Now, another supplementary subject. That is accused number 9. And there are 6 supplementary subject matter on next page that page 2.
Hmm.
Then charges was paid on 15/2021.
Hmm.
Thereafter, examination PW1 in October. Thereafter, on 21/9/2022, the Sonalco High Court deputy trial has been
Hmm.
And now, on 31/10/2022, the Vedanta Vikas Das examination for the PW. Number 2.
Respondent number 2, respondent number 2. Okay, okay. Okay, this is the person who offered and paid 50,000. Okay,
And thereafter,
he is R2, no? Okay,
and thereafter, on 21/11/2022,
Hmm.
there are petitions filed by the median mother, saying booking of 390, Vedanta because of.
okay, okay.
And thereafter, an objection has been filed by the state. And thereafter, on 5/11/2022, they also took a same for the report and the petition was taken. And now, the third case.
Hmm.
These are the ground settings by the
Yeah.
First point is you should go to the approach with the information insert detail diversity 50,000. For declaring the clear communicable market and proceedings of the section 24 of the PCF protects the statement of the
given by these against as an evidence, but such action does not protect you from conducting the office of practice. And third is minor, the act would have been considerably protected if he had done his office. These are the main three contentions. And now the terms, arguments taken by the people in the previous petition that I have been quoted. These are the minor meaning behind. This has been recently argued by. Because of the refuse to proceed against section the Vedanta Department, whether in the FIR was lodged in 78 to 170, and thereafter delay of the FIR 1 year 10 months. And thereafter the informal committed office under section of the PCA. As per the 19, the terms of inquiry into a trial of the offence to appear from the evidence that any person committed any offence from for which such person should be tried together with the accused, the court may proceed against the person of such office and the accused is committed. And section 24 does not envisage blanket protection to the bribe giver. Immunity to bribe giver is provided where he is unwilling to clear a illegal deputy to his public service at least 2 months. And informant and the bribe taker were neither police officer nor were authorized by anyone to carry out any investigation. Therefore, it cannot be held that they are conducting any testing in the before, hence applicable to section 20.1. PCA is amended with effect from 26/7/2018. The amended at section 24 PCA was admitted. As statement, the informant was recorded on both on 31/10/2022, and the informant admitted to his evidence that he paid bribe to the public service on 31/10/22. The protection under section 24 PCA is not. These are the main complaints for the party financial. And cause of action against the errors on the day of responses, the court was going to constrain after section of 24 PCA was released. And now these are the matters at least 5 years.
I've
These
seen
are
that.
my questions. Here, my love, we have seen the FIR which was launched on 17/8/2017 by respondent number 2 that given advance money of the 50,000. Here, my love, the statement I have seen. In his statement at page 49 of the petitions letter. 49 of the petitions letter page number, where he clarified from this statement that 15 lakhs was securing the job. And he had given 50,000 as an advance. That offer acceptance that much of the time. When we already paid the money, then as part of the conviction, the council's matter that he was not protected under the. But my contention is that he has paid as an 50,000. It's a tender to him. Standard to him. Not completed the enter. As such, he will get his option. That's no, I am seeing that the offer is only one.
Then
That will happen when I have only one. The payment is not completed, and I have to say, madam, tender to an offer.
okay. Your argument is that yeah, admittedly it was 50 lakhs or something like that. So bribe, if we go by the word bribe is total is 50 lakhs and that has not been paid, only offered 50,000.
Tender to
Therefore,
offer. That's why I'm saying, my word is little bit different. Tender to offer.
tender to
The offer is continuing.
offer is considered.
In my sense. And now, you know, see, the heading of the important, the might be given in the table the following of the section 24 of the old PCA table. Here, the heading statement by a bribe giver. There's a bribe giver, not to subject into prosecution. The word prosecution is also. Not sending anything contained in any law, so if in any form, a statement made by a person, any proceeding. There is no way similar judicial proceeding. It says whether any proceeding against a public servant for an offence under section 7 to 12, under section 13 or section 15, that he offered or agreed to offer any gratification for any variable feature of public service shall not subject such person to a prosecution. So that's what another prosecution under section 10. One of the definitions of the CRPC, here possibly and this comes in section 2. Section 2 is the CRPC.
Just a minute. Section 2,
2 is the investigation. Investigation. Here it says, my lord, investigation includes all the proceeding under the code. All the proceedings under the investigation. Means, my lord, investigation is also part of it. Here in section says, my lord, the statement made by in any proceeding, not judicial.
for collection of evidence.
Yes. An investigation says includes all the proceeding under this code for collection of evidence conducted by a police officer or by a person who are authorized by the judiciary. Therefore, and in melody, in Techno dictionary also, my lord, the word
Yes.
here the section 24 provides my lord the protection. The right giver by not subjecting to prosecution. Now the question is, what is the prosecution? The prosecution matter, according to Techno dictionary minor definition, here to institute and pursue a criminal action against a person. Means whether institute means an and pursue a criminal action against a person. Again, the prosecution in the Techno dictionary means the commencement and carrying out of any action. Bracket, here is the legal action for criminal code or dispute. Section 24 gives protections not only at the state of judicial proceeding, but at the state of initiation of criminal proceeding to the legal conclusion, arrive at the judicial judgment, and the judicial proceeding is only a part of proceeding. Here, my lord, the prosecutions, the commencement and carrying out of any action or as per technology. Now, again, we come to my lord, the section 24. This section 24 of the earlier PCA state that about statement. Statement means, my lord, we have to say, my lord, this statement is come once when statement is of the fundamental statement at the time of investigation. Made by any persons, any proceeding against public servant of an offence, so far it's related to evidence at the stage of judicial proceeding, hence the procedural in nature. But the second part of the section 24, which provides protection to a right giver against offence, is the nature of substantial right. As protections granted against the legal enforcement of penal provisions, a substantive right is a right that can be protected or enforced by law, a right of substance. The essence of something is essential quality of something as opposed or its mere form. Substantial protections of a right giver rather than form. Here, in this case, newly amended Act in section 28, section 8, creates offence against right giver and section 24 is omitted. If given retrospective of operations, then there may have some minor when it was omitted. There is no any minor expressly or implication has been given. It's a prospective policy. That is not it.
So then it is always prospective.
Yes. If there is no any express. Simply submitted and section 8 is done. That's why section 8 has been ended. And in while of the cardinal principle of the construction in GPC matter, the interpretation of GP. here I have written in my document.
I got it.
It is a cardinal principle of construction that every statute is a prima facie prospective unless it's expressly or necessary improvement made to have retrospective offense. It is more so where the object of the statute is to affect the right of the impose new burdens or to impair existing obligations unless there are the words in the statute sufficient to show that the intention of the legislature to affect existing rights, it is deemed to a prospective only. Nova constitutes today's formal imponere de non parity. It means to me a new law or to regulate what is to follow, not the past. It is in the decision file. Here at page 524 of the manual.
Yes.
So according to the melody, the fundamental police power that is section 24 of this year. And now you must come to the article 20, subclause 1 of melody according to Constitution of India. Page 7.
It's 7 or 12.
Page 7.
Yes.
Page 7 of my notice.
In page 12 also we have.
Yes, page 12 also I have written. Here also I have clarified. According to Article 21, no person shall be convicted of any offence except for violations of law in force at the time of commission of the act charged as an offence, nor be subject to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. And the object of section 24 is to protect a person from disclosing the offence against the public servant. And here, my lord, I have already the meaning of the inquiry, definition of the inquiry. It is there, my lord. And investigations, I have already said, my lord. It's not judicial question, all proceedings come under the investigation. And section 24, the statement, what is, my lord, means, my lord, the 161 statement of the investigation. And moreover, now we come to my lord, the 132 of the evidence. The 132 evidence act also my lord. Witness not excused for answering on the ground that answer will remain. A witness shall not be excused for answering any question as to any matter relevant to the matter in a suit or in a civil or a criminal proceeding upon the ground that the answer to such questions will terminate or may tend directly or indirectly to terminate such questions or that will be exposed or tend directly or indirectly to expose and such witness will announce for future of any time. The 132 also minus the connection to the manifestation number 2. And now here, my lord, I have to refer to judgment matter, fixed matter. This is okay, done, my lord, 2013 PSCC.
But he's not saying Mr. Okay. Hardeep Singh.
This thing, my lord, here, the para 94, 95, 96, 97. I'm not reading all the matter. Here, my lord, the when 319 has been invoked and why it was strongly this is what we have a general measures for the matter of court. So it has been described very differently. Para 94, 95, 96, 97, 95, 105, 106, 47. I'm reading not well of all. What is the degree of satisfaction required for invoking of power of section 319 of this institution? It is very clearly directed by the Supreme Court. And
No, just coming into my mind. what is the benefit you will get making him an accused? How can you be an aggrieved person? Just a question.
Then the moment he is an accused,
Hmm.
he will be an accused in last point. His whole statement.
Hmm.
His poetry statement.
Okay, that will give you a benefit.
That's the law, and that will be a statement of any poetry. That can be relied on. It's not that the poetry statement cannot be relied on.
Hmm.
Your poetry statement can be relied on under section.
No, just what is the purpose of you filing an application to make him an accused under section
Because
390?
he is the person
Hmm.
after being a poet. Now, being an accused who has tried the main money,
Hmm.
he has implicated us.
Hmm.
He has implicated us. He has not only he has implicated me also, that he met me only during the time of the interview.
Hmm.
This man.
Hmm.
His first implication is that he met me
Then interview,
in
then
the interview.
then he was
Then he was asking what are the questions has been asked. I said, no, nothing. So he is the first one, and so he made an RTI. So, yes, apart from my dad, we are only the blanket protection.
that is a question coming to the mind of this court. Why you?
Because I am the one of the accused.
No,
He taught me that-
suppose, just for a moment. Suppose he is not made an accused. How will you be prejudiced?
I'm prejudiced because now his statement
Will become a quick statement of,
not become a coexist statement. It's become now substantial evidence.
Hmm.
His statement on now in the court,
Hmm.
it's become a substantial evidence
Hmm.
implicating me.
Hmm.
But if you become a co-accused,
it will not be a substantial.
he needs some corroboration. So it has caused the prejudice to a man.
Hmm.
Then who has implicated me? A co-accused has implicated me, but you have intentionally. The prosecution says that why you have not brought him as a co-accused? Because you know, the moment you brought him as a co-accused, you need some corroboration under section 30. You need some corroboration. You may not have that corroboration. So rather than going by the straight way,
Okay.
they have brought him as a witness, protect him as a witness, so that he can implicate us also after so many years.
Yeah.
And that is his statement will cause prejudice. Apparently, my lord, he caused very prejudice.
So that therefore you are an aggrieved party.
We are a negative party, apparently. My lord.
Yes, Fukan.
And now, my lord, from the publishers which are there, like, and voting of not necessarily. And what about the articles, 20, chapter 1 of the Constitution? We also do a few of the Constitution cannot be integrated. It is a urban submission and making of the academy.
Yes. Correct that.
What I understood in the argument of the first argument is, as far as reduce also, was when the cause of action is enlightened. According to the petitioner, is 31 and 32. There was no posting in terms of so according to the petitioner, on the date when the cause of action had arisen, that is 31 and 22, there was no possibility. And the argument of 31.
October 2000.
October.
October 2015, there was no proceeding. Even this, there is a proceeding. There is a proceeding. Even this, there is a proceeding and all.
His case is that FIR was lodged on 17/8/17, which discloses that bribe was paid on October 2015.
Yes.
So therefore, on October 2015, he committed an offense. And on that day, there was no proceeding pending, therefore he is not protected under section 24, if I have correctly understood. This is his case. His second limb of argument is, even FIR was lost after the result was declared. So therefore, in terms of the other judgment, the intent of the person is to be seen. And to look into the intent, he brought in the avid cross-examination for a not so seriously hard, but said that it was in no unambiguity in the FIR and other, you have stated that I have paid the bribe. And other argument is that this is not only offer. The intention of the legislature to protect or give protection under section 24 is to the genuine person who offers for a public good or maybe who intimates the investigating authority immediately, but not for those persons who pays and fails, approbate and reprobate for those persons who approbates and reprobates not for them. This is his argument, if I have understood properly. This is his case.
So what is happening?
Yes. Who has already paid according to him is not protected under section 20.
And this is an admitted. Not our thing, this is his admission.
Payment is an admission that I have paid say 50,000 on in the month of October. Then result was declared on 4/2/2016. When I saw my name was not there, then FIR was lodged on 17/8/2017.
1 year take. Now, Manoj, if we go by section 24.
Hmm.
Now, section 24, it is statement by bribe giver.
Hmm.
Not to subject him to prosecution.
Hmm.
Now, here, the clean argument is that at the relevant point of time, there was no proceeding.
Hmm.
Now, this kind of proceeding or section 24, it receives significance in view of the fact that in 26/7/2018,
Hmm.
this has been repealed by the amending act.
Hmm.
In that view of the matter, it also receives some significance.
Hmm.
Because the another limb of argument is this remains no more. Well, he deposed on 31/10/22.
Hmm.
I think this is one of the arguments.
No, it is not argument. They have said that section 24 cannot be made applicable in respect of a person who has paid the bribe, but can be made applicable to a person who has offered. That is their first limb of argument. Second limb of argument is that if we come to even proceeding, then when the offense was committed by the accused, not him, by the accused, by taking money, on that date, there was no proceeding pending. Therefore, the bribe giver shall also be an accused, should also be an accused. This is-
And even then, even the FIR also,
Ah.
filing of FIR does not, the FIR does not come within
The meaning of proceeding. This is his.
Because otherwise, everybody will file an FIR subsequently. And he will be protected under section 24. That is not the idea of the legislature. Tomorrow I'll pay the money. If I don't get the job, I'll file the FIR. After 5 years, after 10 years. Then I'll say, no, I filed the FIR. So there is a proceeding pending. I'm protected under Section 20.
Now, it is not his case that there is no protection subsequently because it was deleted. I do not think this is your case. Huh?
That is a pleading.
I said that the pleadings is that this in the case, criminal case, pleadings is not important. But we'll have to go by the statute. See, subsequently, why this has been amended?
So on last occasion, it was also an argument. We put a question
Yes.
to him that suppose if that being the position, then nobody will come and file an FIR or everybody will be afraid. Okay, if I want to do, the whistleblowers will not come to
So that is
raise.
why.
Then he made an
Yes.
answer that therefore there is an amendment made
Yeah.
and a period was given. Even if you go by that period was also
Yes.
not
So
applicable.
why this amendment has been made last time I have argued? That there's a purpose of opinion.
So that
the genuine people, they will intimate first or within a
specific
time
period in
you have to intimate. So that's why,
otherwise your bona fide will be doubted.
yes, otherwise, that is the why. So rather, the amendment rather supports my case.
That is your
My
argument on
argument.
last.
Rather, the amendment
Hmm.
rather supports my case that the otherwise you're getting the blanket or everybody will get the blanket. Everybody will come tomorrow file a FIR after paying the bribe money. If he is not successful, said I am protected because there is an FIR filed by me.
Okay,
So
so
that's not
even
the
if
result.
suppose, Mr. Talukdar, even if we minus the proceeding and assume that lodging of an FIR is a proceeding, but the offense was committed long back. Offense was committed according to the informant in the month of October 2015. And admitted position in the FIR itself, if we forget other things also, that it was amount was given in the month of October 2015 and waited and job he result was declared on 4/2/2016. So his whole intention was to get the job. That is clear from the FIR. So in that context, whether this argument, you will have to rebut the argument offered or agreed to offer and payment, there is a distinction.
I'll argue on that. But before that.
But that payment, as Mr. Fukan has said, that this is to be treated as offer because admittedly this is not the whole amount,
Part payment.
part payment. It
Part
is,
payment is
no,
not a
he is not, Fukan is not saying it's part payment. Fukan is saying total was 8 lakhs or something, 50 lakhs, I offered only 50,000. So this is an offer.
No, he paid also 50 lakhs.
No, he paid, but it is not.
He paid 50 lakhs.
He-
He cannot say that we have not.
No.
He said only the
No,
entire.
I am saying what Mr. Fukan has argued. No, I'm not saying from my
But
side.
the one thing is that.
If, because we'll have to understand what the lawyers are arguing. Is that it? His argument is that no, this is always to be treated as an offer. So he is saying that there is a distinction between offer and payment.
And so there is a bribe has to be distinguished in two parts. If we agree by his submission, so bribe also, we have to distinguish two parts. If I pay a offer.
If
of
a
5
total amount is 5 lakhs,
lakhs,
if you
if I
pay
1
part,
rupee.
then it is only offer.
If I pay 1 rupee,
That
That
is,
is not a
that is
bribe.
not a complete bribe.
this is not a bribe at all.
Complete bribe.
Not even a bribe, it's not a bribe at all.
Okay,
It's
okay.
just an offer.
Okay, let us
So
hear.
from tomorrow.
Let us hear.
So now. this
let us
bribe
hear
thing
Taluk
is there,
Sir.
my lord. It will be a good suggestion for all the prospective client for this purpose.
Yes,
It's a very good idea. I must salute to this good idea.
yes. Take your seat. Yes.
Even the 49 lakhs will not do.
Mm,
If we go by other way,
mm.
payment is offer was for total amount is 50 lakhs. I paid offered 49 lakhs, 9,900. Then only it's not do. It's a part.
This is not payment. Full payment is
It's
not
not
payment. Yes,
It is half, it is 1 rupee is yet to be
Yes.
paid, so it cannot be considered as that.
yes,
It's a very good idea.
yes,
The live streaming will help us.
yes.
Hello, conclusion has been drawn that I have committed an offence. And on that premise, my lord, the argument has been made. Here the question that would arise is, my lord, at the relevant point of time, before the amendment, that is, my lord, 26, sorry, my lord, it is
It is,
26, 7, 18,
yes,
whether there was a proceeding on. Number one, if before amendment, my lord, in reference to 24, there is a proceeding. I come within the purview of the proceeding, my lord. Now, my lord, first, my lord, my respect to submission is, your lordship cannot proceed on this premise, my lord, that I have committed an offence. The whole argument is that I have committed an offence. A conclusion has been drawn. Your lordship will test it, my lord.
no conclusion is made. Purpose of 319 is, with my limited understanding, if some material comes out to have a satisfaction, prima facie,
Right.
you cannot be convicted on the basis of your statement.
Right.
Whether an offense is committed, suppose taking some evidence, on last occasion we faced with a problem. On hearing was that a person was injured, severely burned, he was hospitalized. Then during testimony, he said that not only the accused who was sent for trial, but other 2 persons tied him up, pour kerosene and all. So he took name of this other 2 persons. Whether court will be within its power under 319 to bring those people to face a trial. That is the issue. It is not an issue that you are convicted on the basis of your statement in FIR or not. The prayer is under 319 to array you as an accused, because according to them, you have committed an offense under section 12. Section 12 by paying bribe. According to them, a person will be protected who offers, states that I have offered. He makes a statement that I have offered in a proceeding, then he will be protected. But when there is no proceeding pending and you have admittedly disclosed that you have paid some amount, an offense has been committed, therefore, prima facie offense is committed, therefore you should also be tried as an accused. This is their case, not that you can be convicted on the basis of whatever you have stated. Again, you will have all the rights of an accused from cross-examination
That's
to
why the Supreme Court said you have to face the trial.
trial.
You will have
All the benefits.
all the benefits. You can rebut,
Hmm.
whatever you have to rebut. But you have to face the trial and to prove your intention. There is no blanket protection.
So therefore, this is not a case, we are not saying that you have committed some offense.
Correct.
That we cannot say, neither we can say, nor the court can say, even the court would have allowed, this court cannot say. Courts at best say yes. From his statement, it is prima facie a case is made out that he
313, the language is 319 appearing to be guilty.
appearing to.
What is appearing?
to-
Not guilty.
Not guilty.
Appearing to be guilty.
You cannot, then it will be a difficult proposition.
Correct. My lord, unlike other cases,
Hmm.
there is a distinguishing fact.
Yes.
And the fact is, a person, my lord, is making a statement
Hmm.
against himself. There are inculpatory statements. There are incriminating statements. So therefore, my lord, your lordship has to consider, while, my lord, rejecting the application of the petitioner, whether the trial court has committed, my lord, any error. Because eventually, what was the material before the trial court? This question will eventually come.
Hmm.
Because your lordship is deciding the correctness or otherwise of the order passed by the trial court.
Yes.
So whether the
In the context of section 24.
in the context of section 319. Firstly, your lordship will decide.
No, section 319 is a power entrusted upon a court to bring somebody as an accused who is otherwise not accused in the proceeding. This is the power given, but that power is to be exercised having a satisfaction.
Yes.
Now, here the satisfaction is, according to Mr. Bora, there is already a satisfaction because admittedly this has been done and he is not protected under section 24. Therefore, the court has committed a mistake. He's saying that this is a proceeding. That much only. Whether you are guilty or not guilty, that will be a subject matter of trial.
Correct.
So according to him, the learned special judge has failed to exercise his power properly or committed an illegality while rejecting that application and applying its mind to section 24 in the given facts of the present case. That is his argument, if I have understood. Yes.
Hello. What I understand from this connection, there are two phases.
Mm.
Firstly, my lord, with reference to section 24.
Mm.
This is my lord an independent issue.
Mm.
The other one is, my lord, exercise of power
Mm.
by the trial court.
Mm.
Having regard to my lord the evidence under 319. The reference of 24 will come in. I'm not saying that will be excluded. But the question of exercise of power, because essentially, my lord, what the trial court will do, he will exercise the power under 319
Mm.
to summon him as an accused man.
Mm.
So therefore, my primary contention is whether the order of rejection, my lord, is incorrect or it suffers from any infirmity. Because eventually, what was the material before the trial court? That will come, my lord.
Yes.
What was the evidence? Because if your lordship says 319, it is very clear. The expression evidence, my lord, has to be given some meaning. 319 says, when in the course of any inquiry or trial of an offense, it appears from the evidence.
Mm.
So therefore, when the materials before the trial court cannot be considered to be evidence, the question is whether the trial court will exercise the power. What was the material? The FIR
Mm.
and the minor, the testimony, the evidence, my lord. Now, largely, my lord, the entire materials are inculpatory in nature. My lord. Those are incriminatory, self-incriminatory materials. My lord. One, my lord, FIR is hit by section 24, 25. Because this is a my lord, material submitted during the investigation before the police.
So according to you, the statement, what is written in the FIR is not an evidence.
I'll
So for the purpose of determination making under section
even
319.
also, my lord, FIR is not an, if I rightly understand, FIR is, my lord, not a substantial piece of evidence. My lord, this will come, my lord, for corroboration.
No, so
Even
therefore, therefore, in exercise of power under section 319,
Right.
and a statement in the FIR cannot be considered.
That is not my argument. My argument is when the my lord, FIR contains inculpatory statements, when it contains self-incriminating statements, my lord, that cannot be considered.
Okay.
Because it is hit by section 25 of the Indian Evidence Act. Number one. Number two, the testimony, my lord, the evidence on 31-10-22. My lord, those statements also, those evidence also, it contains, my lord, self-incriminating materials. And which is, my lord, there is an embargo under section 132, the proviso of the Evidence Act. If the lordship comes to the Evidence Act.
Evidence Act. The criminal based evidence act is not there. No. Just a minute. Okay, evidence check, huh?
Right.
Section,
Section 132, madam. NAD.
yes, just a minute. Section. One 32, witness not,
Witness not excused
Hmm.
from answering on ground that will, that answer will criminal.
Hmm.
So, my lord, he can answer, he has to answer. A witness shall not be excused
Hmm.
from answering any question as to any matter relevant to the matter in issue in any suit or in any civil or criminal proceeding.
Hmm.
Upon the ground that the answer to such question will criminate or may tend directly or indirectly to criminate
Hmm.
such witness who is making the statement,
Hmm.
or that it will expose
Hmm.
to tend directly or indirectly to expose such witness to a penalty or forfeiture of any kind.
Hmm.
Now the proviso, my lord, is important.
Hmm.
It is relevant. Provided no such answer which a witness shall be compelled to give
Hmm.
shall subject him to any arrest or prosecution.
Hmm.
Prosecution mark it, madam.
Hmm.
Prosecution. Or be proved against him in any criminal proceeding, except the prosecution for giving false evidence by such answer. So the exception which is carved is that if he gives a false evidence, then my lord, he is exposed to a criminal prosecution. Not otherwise, for giving evidence which is self-incriminating in nature, incriminatory in nature.
Yes,
So if you are not see the evidence, this is largely inculpatory in nature. Self-incriminating, that even the bride is that manner. So therefore, that part of the evidence, my lord, is hid by section 132. And therefore, it remains inadmissible in law. If an evidence, my lord, is inadmissible, my lord, the trial court cannot consider it.
yes.
So, my lord, the two materials,
According to you, that statement in the proceeding, the cross-examination, that I paid the bribe cannot be used against him.
and that particular
Hmm? Hmm?
cross chief, my lord, it constitutes the entire evidence. If I have read the
So he cannot be used against him.
So therefore, my lord,
Hmm.
my respectful submission, when the order, my lord, by the petitioner,
Hmm.
that was rejected,
Hmm.
while the trial court proceeding, my lord, to reject it, there was no evidence at all in terms of section 319. There was no other material before, my lord, in trial court.
Okay, so you want to say the condition precedent to exercise power under section 319 were not available.
Yes, and your lordship has gone through the 36 stage. It is not merely my lord prima facie case. The satisfaction, my lord, is based on a higher pedestal.
And it's from the evidence. According to you, it's from the evidence.
Yes.
And the FIR is that being it against himself,
By section 25,
section 25.
and my lord, this evidence is by 132.
132.
132.
So therefore, he cannot be
My lord, in fact,
made an
if I
accused.
rely on short judgment, where this thing was discussed, I will not burden your lordship, but only one paragraph. In fact, read it. That is one of the 2017 case.
So therefore, if we go by your argument,
Hello, 12, section 12. The moot question, however, is.
Yes, yes,
The moot question, however, is. For the para 13, 12 months.
paragraph,
Paragraph 12, my.
yes,
The moot question, however, is the degree of satisfaction that is required for invoking the power under section 319 CRPC. And the related question is as to in what situations this power should be exercised with respect to the person named in the affair but not transmitted. These two aspects were also specifically dealt with by the Constitution bench in Hardeep Singh's case and answered in the following. At the time of checking cognizance, the court has to see whether the prima facie case is made out to proceed against the accused. Under section 319, though the test of prima facie case is the same, the degree of satisfaction that is required is much stricter. A two-judges bench of this court in regard of so-and-so held that on the objective satisfaction of the court, a person may be arrested or summoned as the circumstances of the case may require. If it appears from the evidence that any such person, not being the accused, has committed an offense for which such person could be tried together with the already arraigned accused person. But pausing for a moment, what one of the Constitution bench says that the requirement of the satisfaction is much stricter, my friend. Now, here is a case, there were materials before the court, two materials. The court can even, my lord, cannot look into that materials. There are statutory bar under the Indian Evidence Act. In that view of the matter, due to the embargo under section 25 of the Evidence Act and the proviso to 132, those two materials become absolutely inadmissible in law. So far as, my lord, the
this petitioner is
Absolutely.
rational to rational.
had it been a case, there would have been some other material, given by some other witness, then, my lord, this case would have been on a totally different footing. And while proceeding, my lord, in this case, your lordship has to, my lord, take into account that this is a case which is based on self-incriminating and inculpatory statements. So that is the distinguishing fact, my lord, in this present case. So my respectful submission, my lord, much less to have any satisfaction in this case. There was even no evidence as required under my lord 319. My lord, to buttress my argument, I will not read the judgments. I'll place my lord two judgments. This is my lord 1994 to SC 467. Your lordship will come to para 17. This was also a case where the my lord accused was himself the informant. He lost the FIR.
Paragraph 17.
Para 17. Now, what the ethics court says, my lord, some of the sections provisions of the Indian Evidence Act, my lord, have been mentioned. Para 17, I am reading down. Where the first information report is given by an accused himself to a police officer and amounts to a confessional statement. Proof of the confession is prohibited by section 25 of the Evidence Act. No part of the confessional statement can be proved or received in evidence. Now, this is important. Evidence means, my lord, before the court, except to the extent it is permitted by section 27 of the Evidence Act. 27 says the leading of the fact to discovery of the truth. Only that part, your lordship is aware. The first information report recorded under section 154 is not a substantive piece of evidence. It may be used to corroborate the informant under section 157 of the Evidence Act or to contradict him under section 145 of the Evidence Act in case the informant appears as a witness at the trial, where the accused himself lodges the information report. The fact of his giving the information to the police is admissible against him as evidence of his conduct under section 8. He had lost the FIR, that conduct, my lord, can be considered. Evidence Act, and to the extent it is non-confessional in nature. It would also be relevant under section 21 of the Evidence Act, but the confessional part of the first information report by the accused to the police officer cannot be used at all against him in view of the ban of section 25 of the Evidence Act. So therefore, my lord, if the incriminating part, which is in the FIR, that is excluded, nothing remains there.
Yes.
So therefore, my lord, my respectful submission is, since your lordship is deciding the correctness or otherwise of the order passed by the trial court, therefore, on that day, when the application by the petitioner was rejected, in terms of 319,
There is no evidence.
much less, my lord, satisfaction.
There
Because
is no evidence.
what the 319 says, not only evidence, from that evidence, the trial court has to arrive at a satisfaction. And this satisfaction, it rests on a higher pedestal. Availability, evidence of, my lord,
Higher than a prima facie case.
higher than a premise, is stricter. What it seems that it's stricter. So, my lord, so therefore, availability of evidence itself is not sufficient. Therefrom, the trial court has to acquire the satisfaction also, which rests, my lord, on a higher pedestal. Here, in my respectful submission, both these two requirements were accepted. So therefore, my humble submission is, the trial court did not commit any error while rejecting the application of the petitioner for asking to invoke the power under 319. Because
But these are not the grounds of the learned court bureau.
may not be.
That whatever you have argued, these are not the grounds that for this I have rejected.
No, your lordship, my humble submission is, your lordship is exercising the power under 482. The grounds, my lord, of the 482, my lord, is also very clear. but what I find from the petition, neither of these grounds is pleaded. In exercise of the power, inherent power, your lordship can consider this aspect, this is a
No, no,
legal proposition, my lord.
Yes, I can, there is no quarrel on that, we cannot.
Yeah.
But the legality of the order is to be tested on the basis of its reason. Isn't it? What is, let us see the order, impugn order, what is the findings? Is it a case that what you have argued? Here, the rejection, ground of rejection is he was a whistleblower. So the learned special judge says that the offense bribe was given, illegal gratification was done prior to amendment of the act, that is in the month of October 2015. At Satsanga Bihar, Guwahati, as mentioned by the accused in the paragraph 4 of his petition. The date of occurrence in a criminal case is the day on which the incident took place. In the case in hand, if there was any offense committed by the informant as argued, then it would be on the day of payment of bribe to the accused so and so. The day on which the informant deposed in the court during trial cannot be the date of occurrence, as informant was protected on the day of payment of illegal gratification under the provision of section 24 of the PC Act. His protection will continue all on subsequent dates. So according to the court, the question of satisfaction or not satisfaction is not a subject matter. Ground of rejection is that he is a protected person. He has given bribe, no doubt about it, but he is a protected. He is presumed to be a bribe giver by the learned court below. And therefore,
Protected from the day of paying the bribe.
therefore, he is protected. Next finding is the protection will start from the date of giving bribe. This is the findings. So, the satisfaction required section 25, section 138, he has not even applied his mind.
Lordship can always apply or not doing it. Even then, if it is not applied also,
Yes.
lordship can definitely apply that. Right. It's likely on that point, I am considering that the lordship can, even today, even the trial court has committed wrong. Even today,
You want the finality here.
the lordship can, yes. The lordship can.
He wants the finality here.
Not a factual aspect. What I'm
No, I put that as, no, I just, that he has asked, that the trial court has not decided on the basis of this section.
No, but not this the requirement of 319 is
And the 300, the protection under section 25
mm,
and protection under section
38
132.
to
That has not been discussed.
discuss.
These cases that probably as I have understood, these are not legal evidence.
Mm.
So yeah, it is not legal evidence. So it is cannot be taken under section 39.
Yes.
That's probably
My submission is whether the learned trial court has recorded it or not. Yes, since your lordship is deciding the correctness or otherwise, by applying the legal principles on the facts of this case.
Absolutely.
Then there is a new facet you will have to answer to.
Yes, I'll answer it just within 5 seconds.
You want the finality here. We thought that finality will be there. Yes. So court has not gone into all those aspects. Not done. Court's view was that section 24 was repealed on 26/7/2018. and it was applicable on the date of commission of the offense. So therefore, protection, he is a protected bribe giver in terms of section 24, therefore he cannot be prosecuted. This is the findings of the learned court.
Correct, because one of these findings, one of is based on the, one of, application, saying that since the, one of, witness, he deposed on 31/10/22, so therefore the cause of action, cause of action is arisen on that day. So having regard to this aspect, the learned trial court, one of, went back to the pre-amendment stage, saying that when the
Not only pre-amendment says,
the amendment 26/7/18. So before that, 24 was subsisting, man. It was not repealed. And therefore the trial court said that he is entitled to the protection under 24. This is, my lord, one his findings, my lord. So therefore the question would be whether or not.
he is protected on the date of payment of illegal gratification under the provision of 24 of the PC Act. His protection will continue on all subsequent days.
Correct.
So court is not doubting that he has not paid. There is no dissatisfaction that he has not paid. The satisfaction,
Come to a conclusion, my respectful submission. But here essentially what the trial court says, having reference to 24, that the protection is available to him because your lordship will read this judgment not at the findings of the court. Because trial has not, my lord, ended, there is no judgment, so the trial court, your lordship cannot read this judgment that there is a findings on his part. This is my respectful submission.
no,
This observation,
here
there
is-
is an observation.
no, there is no findings on the part
Therefore,
making any accusation against him, but court says that he is a protected under section 24. Who is,
in regard to section 24.
who is protected under section 24?
Yes, I'll satisfy your lordship.
Who is protected under section 24? A person who offers bribe.
Absolutely.
Otherwise, under section 12, a person who offers bribe is a offense and he can be prosecuted as an accused.
Yes.
But in special circumstances, legislature in its wisdom has enacted section 24 to give protection even to a person who commits an offense.
Madam, I straight away will not reply to your lordship's query.
Yes.
I don't know whether I can put it well, eloquently, but I'll try to make it.
Yeah, you are
Now,
always
reading
eloquent.
24,
Yes.
reading 24, which section, my lord? Now,
Reading section 24 is an exception,
Right.
isn't it? It's an exception.
now, the moment
Hmm.
one says, my lord, that he is not entitled to the protection under 24.
Hmm.
Therefore, the necessary corollary is, he comes within section 12, abatement,
Yes.
because he is not a public servant, so he comes within the purview of 12. Now, if your lordship comes to 12,
Yes.
we have to read 24, having regard to 12 and other provisions of, my lord, the PC Act. Because section 24 cannot be interpreted, my lord, in an isolated manner.
Hmm.
In the context, my lord, I will try to show your lordship that it is not only the offer, it is the payment also. Otherwise, my lord, section 12 and section 7 would be rendered odious. I'll show how.
Yes.
If your lordship comes to 12,
Hmm.
my lord, I am reading the unamended act.
Yes, I am also in agreement.
Punishment for abatement of offences defined in section 7 or 12. So therefore, this is relatable to 7. Since, my lord, here we are not related to any consideration amount, only, my lord, illegal gratification. So I'll confine my argument to 7 only, my lord. 11 relates to public servant obtaining valuable things. This is not the case here. So I'll confine to 7. Whoever avails any offense punishable under 7 or 11, whether or not that offense is committed, your lordship will see,
Hmm.
whether or not that offense is committed in consequence of debt abatement, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 5 years and shall also be liable to fine. Now, if your lordship comes to 7. public servant taking gratification other than legal remuneration in respect of an official act. 7 is relatable to 12. Whoever being or expecting to be a public servant accept or obtains or agrees to accept or attempts to obtain. So reading this, my lord, here, not only the offering, but also the actual payment of the bribe. So therefore, if we read section 12 with section 24, and if we restrict only, my lord, to the offering, then one, my lord, is interpreting section 7 in a restricted manner, making section 7 partially nugatory, because only, my lord, one is confining himself to the actual payment. But what does section 7 say? Section 7 says, accept or agrees to accept or attempts to obtain. Not only the actual payment, even the offerings will also come. So therefore, section 24, read with section 12, has to be understood that offer means, my lord, the payment also. Otherwise, my lord,
Therefore,
Payment-
section 24.
payment as well as both offer, not only payment, both payment and offer. So the moment one offers and moment one pays, both, my lord, come within the purview of 24. One cannot say that only when the, my lord, payment is made, then only, my lord, he has to give evidence, he has to prove his, my lord, mental status. Not only that, man. Both, and the Supreme Court judgment, which, my lord, the petitioner has relied on, that is relating to payment. That is not relating to offer. Had, my lord, there been offer, Supreme Court would have discussed, my lord, that in respect of offer as well as payment. We have to understand the Supreme Court judgment in the context, in the facts, my lord, which that was rendered. Reading, my lord, my respectful submission, reading 24 with 12 and 7, my lord, it does not appear that only the actual, my lord, payment is, my lord, included under 24. In both the case, my lord, the person making the payment as well as offering, because, my lord, why I say so, if your lordship reads 24, he offered, there is two expression, man, offered or agreed to offer. The legislature would not have, my lord, used two words in respect of offer alone. While using the word expression offer, it would mean, my lord, that is the payment of, my lord, the bribe. And when it says or agreed to offer, that is, my lord, the offer. Otherwise, if we restrict, my lord, only to, my lord, the payment part and ignore the offer part, my lord, then it will amount to render section 7 as odious, having regard to section 24.
So therefore, if any person gives an offer, gives and makes an payment,
Right.
suppose the person had made a payment of 50 lakhs,
Right.
But he has not given the job, therefore he lost an affair. He is not an accused.
Absolutely, in that case, my lord, my respectful submission is, my lord, in that case, there has to be a.
So we are giving a legality to an offense for the reason that he comes later on and says that he has not given me the job, though I paid 50 lakhs to him. He is not an accused.
My lord,
If we give that interpretation, that will be very helpful for Maham.
No, my lord, my respectful submission. My lord, my respectful submission is, I am reading section 24.
We'll agree,
As it is.
as it is.
Yes, with, my lord, section 12 and 7.
So we'll have to interpret that, otherwise it will be negatory. The section, other section will be negatory until and unless we describe this section 24 as like this.
Because your lordship.
And in case of new provision, then that is to be only the only reference will be that it is to be done within a period of 1 year or 1 month or something like that. You pay 50 lakhs, if job is not given within a month, you come back and give
Madam,
offer.
my
If job is given within month, then
Madam,
you don't intimate, there is no offense.
No, my lord, we don't, lordship will not, my lord, interpret this provision with regard to a particular fact. If your lordship, my lord, interprets, my lord, this particular provision as it is, not having regard to the fact. I'm trying to
What is
say-
the object of section 24?
My lord-
Incorporating section
My
24.
lord, the
That
interpretation.
is an offense. Offering a bribe is an offense.
Yes.
Is not it?
Absolutely, my lord. That is.
And that of offense have some exception has been given. That certain statements should not be used against the person. What is the purpose of doing this?
I don't know. I don't get it.
It is an offense otherwise. Offering a bribe.
It is an abatement under 12.
Abatement, abatement to do
It's an
something,
offense.
offense,
Offense of abatement.
offense of abatement. Now, why this then exception is given that he should not be prosecuted? What was the mind behind the legislation?
Absolutely.
And that has been deleted and incorporated, giving a specific period. That continues. That protection continues.
Yes.
Why? If we interpret the way you are asking, then it will.
I may not be clear. What I'm trying to say.
Hmm.
But my interpretation would advance the purpose and object of the act.
Hmm.
What I'm trying to say, not only the actual bribe giver, but also who offers, both comes within my law. The purview of 12 and 7.
Hmm.
And having regard to 24, my lord, both are liable to prove themselves
Hmm.
that my lord, the criminal intent was not there.
Hmm.
My interpretation is not to restrict
Hmm.
the my lord offender.
Hmm.
My interpretation would, my lord, advance the purpose and object of the scheme. But I may not be able to put, my lord, what
No.
I'm trying to say across your lordship, my lord.
Hmm.
So, reading 24,
Hmm.
along with 12, my lord, the argument saying that it will only apply in respect of the actual giver. This argument fails, my lord. This is my humble submission. It applies to both, not only the actual giver, but also, my lord, who offers to give the bribe. Because 12 has to read with section 7. 7 not only deals, my lord, with the actual giver, with the person who is offering the bribe also.
Yes.
So my respectful submission, my lord, before the amendment, the bribe, the purported alleged bribe that was offered, and immediately, my lord, thereafter, not immediately, thereafter, my lord, the FIR was lost. Now, the date of lodging the FIR, it, my lord, received significance in view of the fact that subsequent thereto, my lord, it was amended. So before amendment, my lord, the FIR was lost.
Hmm.
And the police, my lord, collected evidence pursuant to the, my lord, filing of the FIR. It was registered. So in view of, my lord, section 2H, the collection of evidence, my lord, is a proceeding.
Hmm.
If your lordship says 2H,
Hmm.
now, my lord, the section 24, expression any proceeding.
Hmm.
My lord, this cannot be-
Accepted.
It's a given a restricted meaning. It's not a judicial proceeding alone.
Hmm.
It is all comprehensive, including all proceedings, because the expression any is used. So therefore, to refer to the, my lord, provisions of this act, to say, my lord, that it would be, to CRPC, it would be only the judicial proceeding, in my humble submission, is misconceived. Because this, my lord, is any proceeding. And if your lordship goes by 2H,
Hmm.
proceeding is not, my lord, defined. Investigation says include all proceedings.
Hmm.
Under the code, for the collection of evidence conducted by a police officer or by any person who is authorized by a magistrate in this behalf. So that proceeding was, my lord, there, very much there. And in that view of the matter, there was a proceeding under section 24. And therefore, this proceeding having taken place, I am told, my lord, that there was a 164 statement also. He appeared before the magistrate. That, my lord, was recorded before the amendment, the repeal of section 20. So eventually or essentially, that proceeding was very much there.
Yes.
So, my lord, my submission is
Hmm.
that even though the trial court had not recorded
Hmm.
that there was no material,
Hmm.
your lordship, by not exercising the original jurisdiction, can consider the respect of the matter.
Yes, Mr. Bora.
Two things I will just answer it in a very short period of time. The first one, it is to 132 proviso. Then
Yes.
section 24. 25, he said that the bar contains regarding the evidence.
Now you want me to go to section 24.
25,
I am at
Evidence.
132 evidence.
120, he said that the proviso to the
132.
132
Hmm.
reverse the trial court to take that as an evidence. Reverse the trial court from take it as an evidence. That is his argument. So 319, to invoke 319, there has to be some evidence. First of all, as I have understood further. So it is as if it is not legal evidence. Because there is a bar containing the 32. So proviso. So this is not a legal evidence, so that the trial court cannot invoke this by virtue of this power under section 319. There is no legal evidence for him, so he can't invoke 319. As far as my understanding, probably subject to lordship. So first thing, the proviso said what?
Compelled.
Said,
Compelled.
who has compelled him? His own statement. Whether he has been compelled to give evidence. Compellation is something else. When we read the provisions up or down, then the compellation we can forget about. But if we read it,
Because it is not a statement on his own volition. So therefore that cannot be used against him.
so
Here it's a word is used provided that no such answer
here,
which say witness shall be compelled to give,
here is a
shall
voluntary.
subject him to
Yes.
any arrest or prosecution.
Yes. It is
Because
compelled.
this relates to Article 20.
Yes. Then again, the Article 20 also says it has to be compelled.
Compelled.
You cannot compel, but if it is voluntary, then it is application is no. First of all, the second one again, the section 25, he said the FIR is barred. The case is self-incriminating FIR is also barred under section 25.
Just a minute, let me go to now 25.
No statement, confession to a police officer not to be proved.
That is a confession before the 161 statement.
No, madam, even the confession also, let us take it as an FIR confession. Let us take it history. He said the FIR itself is a confession because it was an incriminating, so it cannot be taken as an evidence on record. That is the submission. Now, the answer in the 24 itself. So let us read this 24 again. PCA. It's a special act, my love.
Not special.
What is the first word, my love? Let us read it again. Let us read it again. 24.
Any law for time being in
Yes.
force.
Notwithstanding, it's a non-obstantive clause. Anything. It's a non-obstantive clause. Section 5 of the CRPC will determine It's a non-offensive clause, notwithstanding anything contained in any law. That means either in the Evidence Act or in CRPC, wherever. Even in the IPC, that's why the IPC judgment he has followed. It's a 302 offense. That's why he has got the benefit, because there is no option, no offensive clause. But this is a PCR, special act, which is said the first line that the notwithstanding anything contained in any law for the time being enforced, any statement made. That means if there's a bar in the CRPC, if the bar in the Evidence Act, that is not applicable under section 24. That's all. Then the next one, that's very more dangerous situation has been propagated that we have to read section 12 with the section 24. While 12, when it comes to 12, I'm a public servant, my lord. If the private person comes to offers me a bribe, if I lodge an FIR, is liable under section 12. It cannot be prosecuted under any other provisions. So section 12 is different. When a public servant accuses a private person that this man has offered me a bribe, there's no need for actual payment even. That's why section 12 is different. There's no need for actual payment. That offer itself to a public servant is an offense. And section 7 is different. Section 7 is that when the public servant accepts the bribe for him or for the other person from a private person to do an illegal act. So now they are saying that the other person who has paid the money, instigating the public servant, you accept this money, is protected just because he has filed an FIR, it's a prosecution. Filing an FIR itself is a prosecution. So I said filing an FIR cannot be a prosecution. So tomorrow I file an FIR against anybody, the prosecution is pending, that means. If the prosecution, if that is the prosecution is pending, so if there is an FIR against me, and I have applied for a job, do I need to read that the prosecution is pending? If I need to apply for the passport, or High Court judgment I have supplied, I'll give it that judgment also. The long way that the FIR is not a prosecution, otherwise it will create a chaos. Everybody tomorrow will subject to a prosecution. Everywhere, everybody is being prosecuted. That's not the FIR, is not a prosecution. And the investigation starts after the registration of the first word indeed, H.N. Risbach said, the proceeding towards the place of occurrence is the first step of the investigation. That is the H.N. Risbach, long back 1955. The proceeding towards the place of occurrence is the first step of the investigation, not before. So, my lord, the answer is 24, is a special act, not offensive law, governed by the section 5 of the CRPC. CRPC 5 is very clear, my lord. It's a saving clause, my lord. So, the section 25, section 132 has no application at all. And the judgment cited by my learned friend, it is regarding the IPC, because the IPC offences is section 24 is not.
Exception is not there.
That exception has not been curved in the Special Act, in the IPC. This exception is created by the earlier act.
And I think that's why I think the learned court has not gone into those 319 provisions.
That protection. Because that not understanding anything in the content, there's no need to go into the other protection available at a time. That's not available under section 24. And yet, so everybody, that's it why, otherwise, as I'm saying, repeating myself, if that be so, the filing of an FIR by an accused by giving a bribe, the moment he fails to get the job, is protected that way. It's a very dangerous situation now. If you go to that accepted proposition. It will get a dangerous box.
I'm thinking of Delhi when to dictate this order.
And the Bhavik Singh's case by law, 319, yes, power of the 319 is different. The material lordship has, the court has to see the what material has come. Modern prior, that's not disputed. But whether the learned trial court has gone into that aspect, madam.
No. No.
So, he has not gone into that aspect that whether the material place already come before as an evidence. Whether there is a chance of conviction or not. Because the law in the 319, the purpose of 319 is more than finance.
Yes, more than that.
Court has to see whether there is a chance of conviction by using those evidence. But the trial court has not gone into. But he has gone into
Because
only
trial
protection.
court views that he is protected under section 24.
No,
Maybe thousands of material
Thousands of
evidence,
material, yes.
not necessary to go into,
Yes.
because he is protected under section 24.
The mountain load of evidence, but he is protected.
Protected, you might have,
Yes.
that's why he is not
Even
gone
the
in.
confession also.
Yes.
There may be a confession also, but his confession is
Because he is
protected.
under section 24.
Protection.
His statement, he cannot be
Because
used.
confession also is protection.
Protection.
So everything is protection. So the 319, so and the lordship will say, when the prosecution and the investigation.
Your case was that case is made out
Yes,
because he had no protection.
no, but
Under
the material,
section-
already there is an evidence, the material is all own FIR.
Hmm.
His own evidence.
Hmm.
Admitting that he paid the bribe long before.
Evidence, everything is there. So,
FIR
and
is
he's
there.
not, since he is not protected, therefore application under 319, it is more than prima facie.
More than
That is
crime.
your case.
Because the more than privacy is covered, I am not relying on the other's evidence. Madam. I am relying on his own statement, which is not under any protection. Because his own statement in the court is also not under protection because he said he paid money.
Not
If you-
offered.
If you said that I have offered money, he is protected. In the evidence, during the course of the trial. The moment he said that I paid money, is that protection 24 gone. So that's why his statement under the act, in the statement also, in the court, in the proceeding also, is not protected. If it
Okay.
is, and the 1999 lordship can go to that, there is a material, and as I said, the 12 has no application, 12 and 40, and the other judgment cited by my learned friend. And the proceeding definition, lordship kindly see, this is the AI 1968. Last time I have given a copy of
Then it's there. You have given.
para 12. Just one line.
Paragraph,
Paragraph 12.
just.
I've marked it also. If necessary, I'll give you.
No, that is there. Sometimes when you keep things meticulously, you will not find it. Which judgment?
AI
1968.
68. Supreme Court 938.
Paragraph 12.
Lakshmipat.
Paragraph 12.
Yes.
Lakshmipat, Suraria and others.
Yes. Paragraph
12. Isn't it? Okay.
So a criminal proceeding means a criminal inquiry
I've read
or
it.
a trial.
Mm.
Before a court.
That's all. I'm obliged, only one line. The non-obstant clause in 20, in my respectful submission has to be understood in respect of this context. So the provisions of the Evidence Act, in my respectful submission cannot be made here. It has to be understood only in the context where, my lord, the non-obstant clause has been added.
Yes. When? Please. Tomorrow too, we are not having dispense. Yeah. Yes, Mr. Sharma.
Item number 65, my lord, is appearing has come up from the
Item of,
all along, my lord.
what is the item 65?
65 is the, so hearing item, my lord. So let us fix it and next. There is no specific date subject to specific date, my lord.
What was that?
The hearing matter, my lord.
Which year?
22.
Revision or appeal?
It's a board executive.
Crossing. Stays there.
Take.
Already admitted.
Already.
According to the respondent, the complainant lost her father. The document prosecution is like this. These are very short dates.
Not been able to handle so much of
After
cases.
Puja.
All cases are issues are short. In this case, we thought that we'll dictate and finish it up. And you have seen. Week commencing from.
After the puja, that's why I was calling my lord, record his name, my lord, that he has appeared. Up to that extent, my lord, I am acting, but not after the, not before puja.
No, let him have a date before puja also. Let him come. Before puja, do you think that anything is possible? From tomorrow onwards, we'll stop hearing all these matters. Already one is pending, almost complete dictation. We will have to deliver that.
Hima is also there.
Jima too, he has taken time today.
Next week is coming.
Next week is coming. That we'll have to. My idea was not to take anything in during puja vacation. That luxury will not have, like.
Something I'm telling you about something to the board.
Give a date as per your convenience.
In November,
Yes, give a date. November.
14th of November.
Mr. A.M. Bora and Mr. Sharma. Sorry, Fukan. A. Fukan. Due to paucity of time, the matter could not be taken up. Accordingly, release this matter on 9th of November 2020. Interim order pass and shall continue till then.
All right.
Thank you.
Right. Now, what to do about this? This is having some urgency. Either way. After tomorrow.
All right.
Oh, Saturday, Friday, Monday, give it on Monday. Do you want me to go through those issues also?
I leave it to-
319, tell us.
I leave it to law.
List it on Monday. Parties are hard at substantive length. List is hard Mr. A.M. Bora, learned counsel for the petitioner. No, hard the parties at substantial length. List is matter on 18 for concluding argument. But that will not be concluding argument. We'll try to finish it. No argument.
Delivering the
So you have written it to be an argument. If something you may require some questions here and there. That's why we have kept it that earlier bit at 14th. Okay, 14th. 14th is a holiday, I think. Diwali.
Reopening.
Diwali, the next day.
Okay, next day after Diwali. And what are the other matters was?
71.
Yes, where is the petitioner? Hearing concluded, judgment reserved. No way out.
72.
Never the property. Please, hello. You are the state of Assam. What is where you agree? Now, where is the impugn order? Yes. Really, ask to draw departmental proceeding against these people. Affidavit is in the front. I'll ask for the departmental proceeding. Page
Page 20 of the petition file. If you are looking into the affidavit. Page 22 is the operator part regarding the input.
who looks into this?
Otherwise, they would see us again. The program is wrong.
No, ঠিক কৰিব যাব কে লাগে যেতিয়া ফাইল কৰিছে তেতিয়া পিছফালে দিব লাগে না আগফালে দিব লাগে হা hopeless or I'm not getting anything. No petition, all are affidavits.
So, look into the affidavit in operation. So, look into
to page number 129 of the affidavit. Which is the same thing.
129. Yes,
Starts from page 151. Regarding the immovable property.
yes.
Further, the report of the IU Surosit, warehouse godown of Maruti quality products that is situated in Chhatrapati Industry Media is the case of property of the same case and same is preserved as crime scene. The property has been preserved as a crime scene. As such, no one is allowed to enter into the state. Petitioner in his petition has stated that.
Mr.